November 18th regular meeting of the High Point City Council. Here with me at the dais are the council members Harmon, McKeever, Mayor Pro Tem Holmes, and council members Moore and Andrew. Before we go into our agenda, we'll ask everyone here with us to join us, standing for a moment of silence and Pledge of Allegiance. Amen. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We have our agenda for this evening, and I'll ask from the members of council if there's any items on the agenda that need to be adjusted before we move forward. If there are no adjustments, then we'll entertain a motion to approve our agenda.
Motion to approve. Second.
Motion has been made by Mayor Pro Tem Holmes and seconded by Councilman Andrew. Any discussion on the motion to approve our agenda? All those in favor, please signify by saying aye.
Aye.
Any against? The ayes have it, and we have our agenda. First item on our agenda is a proclamation. This proclamation is in acknowledgement of National Hunger and Homelessness Awareness Week. And so I'd love to invite up some folks from our community who are doing some really great work around this. We have Carl Veerling from the Greater High Point Food Alliance. Will you come on up, Carl? And Ms. Sharia Burnett from Partners Ending Homelessness, two agencies who do such incredible work. We're actually going to move over here to the center, and I've got a proclamation that we're going to read. And if you'll bear with me, we'll get through it. Whereas each year, the week before Thanksgiving is designated for Hunger and Homelessness Awareness Week, with the intention to educate the public, draw attention to the problem of poverty, and build up the base of volunteers for local agencies working to address these issues. And whereas annually the National Coalition for the Homeless and the National Student Campaign Against Hunger and Homelessness have sponsored National Hunger and Homelessness Awareness Week, which began in 1975. And whereas the goal of this week in High Point is to educate our citizens about the many reasons people are hungry and homeless, including the existence of prevalent food deserts and the shortage of affordable housing for very low-income residents. And whereas through community service opportunities, citizens are encouraged to support those organizations committed to sheltering and providing support services such as meals and food supplies to people in need. And whereas the intent of National Hunger and Homelessness Awareness Week is consistent with the county-wide efforts and activities of the Guilford County Continuum of Care and its many partner agencies and organizations. Now, therefore, I, Cyril Jefferson, Mayor of High Point, North Carolina, do hereby proclaim November 17th to the 23rd, 2024 as National Hunger and Homelessness Awareness Week, and ask our citizens to join the more than 700 colleges, high schools, and community groups across the country that will come together during this week to raise awareness about the pressing issues of hunger and homelessness. Can we please give it up for the organizations doing such incredible work? Do you all have some people here with y'all as well? Can we invite them up, some of the folks who are here as well? If you came and you're here for this proclamation, we'd love to have you come up with us. Pat, are you here for this? Okay. You're board member for Open Door Ministries. I thought you were here for this. I'm sorry. Anyone else here for the proclamation? Okay. All right. Let's do this. Let's give you both one. You'll stand in the middle. And then if we get one more on this side and you two on that side, that would be perfect. Thank y'all so much. Thank you. The first order of business is to adopt our consent agenda. You all have the agenda there. Is there a motion to approve our consent?
Second.
Motion's been made by Councilmember Moore and seconded by Mayor Pro Tem Holmes. Any discussion on the motion to approve our consent agenda? Hearing none. All those in favor, please signify by saying aye.
Aye.
Any against? The ayes have it, and our consent agenda passes. We have one item for general business. This is item 2024-407, which is a quasi-judicial evidentiary hearing. The Piedmont School Incorporated, special use permit 24-01. This item was continued from the October 21st, 2024 City Council meeting. A request by the Piedmont School Incorporated to consider a special use permit request to allow a major and minor school use type as listed in principal use table 4.1.9 of the development ordinance in the residential single-family -3 R3 district. The site is located along the north side of Old Mill Road, approximately 200 feet east of Netherstone Lane and 815 Old Mill Road. At this time, I'm going to pass it to Madam Attorney to do introduction for this proceeding.
Thank you, sir. Before the mayor opens the special use permit hearing that's on tonight's agenda, I'm going to give a brief overview about the quasi-judicial process that applies to a hearing like this one. A quasi-judicial hearing is an evidentiary hearing. That means it is like a court hearing and will be recorded. State law sets specific procedures and rules concerning how this council must make its decision on the special use permit. These rules are different from other types of land use decisions like rezoning cases, which require a legislative public hearing. This is also very different than the public comment period the council offers, during which time the public may speak about anything that they wish. These proceedings instead will be governed by the rules of procedure of this council, the city's development ordinance, and Article 4, Chapter 160D of the North Carolina General Statutes and other applicable law. The council's discretion is limited, and it must base its decision upon competent, material, and substantial evidence presented during the hearing. The council is constrained to consider only facts and must apply the standards in the development ordinance and state statute to these facts. If you will be presenting evidence, please focus on facts and standards, not personal preference or opinion. This meeting is open to the public and everyone is welcome to attend. However, participation in a quasi-judicial evidentiary hearing is limited, and only parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the following. First, the applicant. Second, the City of High Point staff. Third, people or entities with an ownership or lease interest in the property itself. And fourth, individuals who can show that they will suffer special damages distinct from the rest of the community or general public as a result of the decision. For certain topics, the council may hear opinion testimony from expert witnesses. Individuals providing expert opinion must be qualified as experts and must provide the factual evidence upon which they base their expert opinion. Please note, only experts may testify on certain matters, including but not limited to property values, traffic impact, and anything else that an expert would be required to testify on. At its discretion, the council may allow other non-party testimony so long as it is competent, material, and substantial evidence that is not repetitive. Non-party testimony should be limited to facts and should be relevant. This is not the time or place to offer your opinion, policy suggestions, conjecture, speculation, or anything else irrelevant to whether the matter under consideration tonight meets the development ordinance standards. I will now briefly explain what approval of a special use permit entails. A special use is a land use that may be appropriate at some locations within the zoning district, but because of its nature, extent, and external effects, requires special consideration of its location, design, and methods of operation before it can be deemed appropriate for the location. Before granting a permit to allow the special use, City Council must conduct a quasi-judicial evidentiary hearing to determine whether the proposed special use meets the required review standards per the development ordinance and North Carolina state law. as provided in Section 2.4.12.c of the Development Ordinance, a special use must be approved upon a finding that the applicant demonstrates the proposed special use, number one, will not materially endanger the public health or safety if located where proposed. Number two, complies with all required standards, conditions, and specifications of the Development Ordinance. Three, will not substantially injure the value of the abutting land. Four, will be in harmony with the area in which it is to be located. And five, is in general conformity with the city's adopted policy guidance. Please note, the applicant has the burden of showing that the special use permit request meets all five of these standards. Finally, appropriate conditions may be imposed on any special use permit, provided that the conditions are reasonably related to the special use permit. And with that, I'll turn it back over to you, Mayor, for the hearing.
Thank you, Madam Attorney. And now we'll open the hearing for application SUP-24-01. This is a request by the Piedmont School for a special use permit to allow a major and minor school use type as listed in Principal Use Table 4.1.9 of the Development Ordinance in the Residential Single Family 3 R3 District for the property located at 815 and 829 Old Mill Road. This special use permit application is being considered pursuant to Section 2.4.12 of the Development Ordinance. Before we hear from the parties, we need to check for any conflicts of interest or ex parte communications. The parties to this case are entitled to impartial council members. A council member may not participate in this hearing if they have a fixed opinion prior to the hearing that is not susceptible to change, or if they have a financial interest in the outcome of the matter, or if a close familial business relationship is had with an affected person. Additionally, council members must disclose any ex parte communications, or any communication about the case outside of this hearing. They may include site visits, as well as conversations with party staff or the general public. First, I will offer for the record that on August 26, 2024, I visited the Piedmont School before I was aware of this special use permit request. Are there any council members who have any partiality, conflict of interest, or ex parte communication to disclose?
Mr. Mayor, I'd like to disclose an ex parte communication on 17 October at 1610 local. I received a voicemail from Ms. Jenny Parker. I returned her call at 1632. She described that, questions about this meeting. I told her that I cannot receive any information outside of this meeting, and terminated the conversation about 8 minutes into it. On 18 October at 1607 local, I called her to inform her that the meeting has been moved from October 21st to this date. And that's the last communication I've had with her.
Thank you, Councilmember Andrew. Any other council members have any partiality, conflict of interest, or ex parte communication to disclose?
I will stay, I don't believe that I do, but from the legal standpoint, I have a family member whose property adjoins the property.
Do you believe that to, are you saying?
We've had no discussion.
Just disclosing it, okay.
Yeah,
So
no
you're still impartial for the hearing tonight?
I do.
Absolutely.
Hearing none, we will proceed with the hearing. Standing determination for a party. At this point, we'll check to see if there are any other individuals aside from the staff and the applicant who wish to participate as a party in this case. As a reminder, based on what Madam Attorney shared at the beginning of us opening this proceeding, a party is different than an individual who wishes to speak during non-party testimony. So non-party versus party. Only an individual with legal standing has rights to participate as a party and present evidence, call witnesses, and make legal arguments. Aside from the staff and the applicant, is there anyone wishing to be a party in this matter? Mr. Vaughn, if you'll come forward, state your name for the record and let us know.
Indeed, a privilege to be here. I am Don Vaughn. I'm an attorney in Greensboro. Very pleased to have served on the Greensboro City Council for 7 terms, 2 as Mayor Pro Tem, so I know what your job is tonight to do. I also served 2 terms in the State Senate, 1 as Deputy Pro Tem. I'm adjunct professor of state and local government at Wake Forest Law School, have been for 10 years, and soon will be adjunct professor of state and local government at the brand new High Point Law School here, and I'm proud to do that. But here today, I'm asking for standing for the adjacent property owner, Seven Oaks Bed and Breakfast, from Ron and Dorothy Walker. You two stand up. They own the adjacent property. It's within several hundred feet of this particular property. We believe that they will be able to show special damages in this case once they testify. I can't testify to the special damages. They have to do that. We would ask for standing in this particular matter for them. There may be others here too. I know some others we're talking about coming, but I represent these two here and their ownership in Seven Oaks Bed and Breakfast. Ask for standing.
Mr. Vaughn, thank you for that information. Will the parties please come forward?
May I stand with them up here?
Yes, sir.
Thank you.
Will
Ron,
you-
you want to come up here?
Will you state your name for the record, and since you wish to act as a party to this case, we have to make a determination in terms of your standing. To have legal standing, you must show you will suffer special damages distinct from the rest of the community and general public as a result of the decision. Please explain to this council how you will suffer special damages if the special use permit request is approved.
All right. Thank you. The current zoning for 815 Old Mill Road is R3, designated as low-density residential, which we have established.
Excuse me, will you state your name just for the record?
Yes, Ron Barker, co-owner, Seven Oaks Bed and Breakfast.
Thank you.
Good. As I was saying, R3 does allow for limited commercial entities. Any request must be made before High Point City Council. Seven Oaks completed that request in 2011 and subsequently was granted a limited use permit. When Seven Oaks returned later to Planning and Zoning to request an amendment for limited events under 50 guests, we were told definitely no, citing the disturbance to the community that outside events would create. Now, the Piedmont School comes before council with the largest expansion to date within the Old Mill Road community, a much larger facility than this neighborhood has experienced to date. While the Piedmont School is presenting a plan that they feel offers adequate sound, light, and buffering barriers, it is yet to be determined that these barriers are adequate. And I will step back for a minute when Mayor Jefferson indicated that he went over to the school property. And to my knowledge, that Planning and Zoning is the Technical Review Committee. I hope I'm correct. There has been no on-site visit to the Seven Oaks property to evaluate the proximity of the school's expansion, specifically the athletic field complex, directly adjacent to the Seven Oaks Bed and Breakfast house. So that would indicate that there's no complete technical review has been completed, but there has been a visit to the school, not Seven Oaks. This is an untried proposal with no proof that the proposed Type B planting yard will provide enough protection for surrounding owners. For at least 10 years, we, Ms. Barker and myself, have dealt with numerous disturbances on both the Piedmont School and Seven Oaks property, to include extensive litter from beer, liquor, and unfortunately, needles, which would indicate drugs were being used on the properties. One of the former employees, I believe, of the Piedmont School, she and I were out there cleaning up one day when we discovered this material. Trespassing has and continues to be a problem as recently as several weeks ago when a car was doing burnout on the parking lot. Police were called to the school on more than one occasion. These are just a few examples of the events that warrant additional infrastructure planning on the part of the Piedmont School and the City Technical Review Committee concerning the barriers, or what they refer to as the buffering, around this project. An opaque barrier high enough to block both sound and light continuous on the entire length of the east boundary of the Piedmont School, along with natural sound absorbing landscape, should be required by council before considering the Piedmont School proposal. With that, I implore council to continue this request until additional measures are taken to ensure the quality of the community, not just Seven Oaks, the entire surrounding community that's been out there established for many generations, that this community will be preserved. Having met with property owners surrounding the school property, they also share the same concerns. Many of them whom I visited today unfortunately had family obligations, other issues that prevented them from being here tonight, but they are sharing our concern.
Mr. Barker, I'll note that this section here is just for us to determine if you have standing.
Correct.
You'll have a chance to actually give your full testimony when we get into the hearing.
Standing is such that she and I, my wife and I, are owners of almost 40% of the boundary on the east boundary of the Piedmont School. We stand to be impacted by the events on the athletic complex for the proposed athletic events, baseball, soccer, lacrosse, other events, from the lighting, the parent participation. The proposed Type B planting yard does not provide an adequate barrier between Seven Oaks and the school, which is what would be conducive to the community. That is
Understood.
our expertise.
Does staff or the applicant have any objection to these individuals being considered as a party to this matter?
Mr. Mayor, I'll let the applicant attorneys talk. Please, the attorney for the city staff. The microphone. Okay.
Nick Tosco, attorney for the city staff, and we do not object to the Barkers being considered parties for the purposes of this proceeding.
Does the applicant object to it?
No, Mr. Mayor, we do not object to participation.
Please note that the applicant's attorney stood up and noted that they do not object to the individuals being considered as parties in this standing.
Procedural question, was he sworn?
No, we've not gotten to that point yet.
Okay. After I asked if he would be sworn at the appropriate time.
Yeah, thank you, that's
Thank you.
coming next.
Yeah, that's coming up.
You'll get a repeat performance.
At this time, is there a motion regarding whether these individuals have standing to participate as a party in the matter?
So moved.
Second.
Thank you. There's a motion for approval, is that correct, Councilman Moore?
Yes.
And a second, Councilman Andrew, to approve them as being a party in this matter. Any discussion on the motion? All those in favor, please signify by saying aye. Aye. Any against? The ayes have it by a vote of 9-0. The motion that Seven Oaks Bed and Breakfast co-owner Ron Barker and
Dorothy Barker.
Dorothy Barker have standing to participate in this proceeding as a party is hereby approved. At this time, the city clerk will administer the oath for all individuals present who intend to provide witness testimony. Only those individuals who are sworn in will be allowed to address the council. If you believe there is any chance you may want to testify in this case, please come forward at this time. The attorneys for the parties do not need to be sworn in. So we'll go ahead and have the applicant, staff, and the individuals who just had their legal standing determined. So Mr. and Mrs. Barker, if you'll come forward to be sworn in. Madam Attorney, this is also when any special witnesses, expert witnesses will come forward, right?
That's right, anyone that's going to put forward testimony.
All right, so if there's any expert witnesses, you can come forward. Attorneys do not need to be sworn in.
Raise your right hand. Do you solemnly swear or affirm that the testimony you are going to provide tonight in this public hearing is the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, Madam Clerk. The parties have the option to offer an opening statement if they so choose. As a reminder, please focus on the legal standards and avoid personal opinion or speculation. Does anyone wish to make any such statement?
Mr. Mayor, Nick Tosco again, attorney for city staff, and the applicant's attorney and myself have agreed to forego opening statements and proceed directly with testimony. I don't know if the attorney for the Barkers feels the same way.
Mr. Vaughn and Mr. and Mrs. Barker, do you all wish to have an opening statement?
In the spirit of cooperation, we will agree to no opening statement.
Let the record reflect that Mr. and Mrs. Barker's attorney has indicated that they do not wish to have an open statement and will forego that. We'll now move to the portion of staff testimony. Council is ready to hear the staff presentation and testimony for application SUP-24-01. Before you begin, please confirm for the record just your name and the role in which you're serving.
Mr. Mayor, before we get to city staff, I did just want to enter in, you all have before you a joint stipulation that the applicants or the applicant and the city staff have agreed to in order to try to expedite the hearing such that the evidence and the exhibits that are before you in the agenda packet have been looked at and reviewed by both the applicant's attorney and myself, and we agree that they're authentic and that there's no objections and no need to enter each item of evidence. So that's the first thing. And the second thing is that the expert witnesses in number 3, we do not object to any of those being designated as expert witnesses, and they do not object to Mr. Herb Shannon being considered an expert witness. So that's the joint stipulation that's signed by both the parties, and you can hear from the Barker's attorney.
I would be remiss in my duties to the North Carolina Bar, Greensboro Bar, if I agreed to that. I do not agree. I have not seen that. We just received the agenda at 2:05 this afternoon by email, so I would object to that.
Your objection is noted.
Thank
Mrs.
you.
Vaughn. Thank you.
And Mayor, just to clarify, he just received the joint stipulation this afternoon when we learned that he was going to put forward, he was going to be a party. Certainly, the staff report has been out for some time. For the record, just to clarify.
Okay. So for the record, this information's been out for some time, and we recently learned about the Barkers being put forward as parties.
Exactly.
Okay. Any questions from council about that?
Madam Attorney, seeing as the Barker's attorney has lodged an objection, how does that affect proceeding?
It doesn't. It is just, he has objected to preserve it for the record, but there's no determination that council needs to make. So the staff and the applicant have exchanged information well in advance over the several past weeks. And so the hope, again, as Mr. Tosco stated, was to kind of expedite instead of having to enter every single exhibit that's already in the staff report. This is just, essentially agreeing that everyone has seen everything and it's authentic. For the record, certainly Mr. Vaughn's objection is noted.
Thank you.
Thank you, Mr. Vaughn.
Thank you.
Having heard staff's presentation, does council have any questions for staff?
No, staff.
Staff has not done the presentation. Apologies. Mr. Shannon,
Yes.
will you please, when you get the chance, make sure just state your name for the record and just affirm that you have been sworn in?
Yes. To the right. That one, yeah. Herb Shannon, Senior Planner with the City of High Point Planning and Development Department, and I will be providing you with a summary of the staff report that is provided in your packet. And yes, I have been sworn in. Mr. Mayor, City Council, members of the public, the applicant, the Piedmont School, is requesting a special use permit, as been noted, to allow expansion of an existing, or to allow a major minor school on this site. This first slide is a overall location map of the site as it relates to the city limits. Let me just pull one thing up here. So the area highlighted in red is the site in question is along east of Johnson Street, north of I-74, south of Ski Club Road. And this is an aerial photo of the site. that's located in the northern central portion of the city of High Point off of Old Mill Road. Before we get into the details of the proposal, I want to provide some background information to address any confusion based upon some phone calls that staff has received. First, I would note that this is not a rezoning application. Staff had received some concerns from the members of the public that this is a rezoning request. The site currently has a residential single-family 3 or R3 zoning designation. This is an exhibit of the city's zoning map for this portion of the city. That area highlighted in yellow are the lands that are designated R3. This is not changing the zoning. This is a special use permit request, and the city attorney has already given you an explanation of the special use permit. To the north, south, and west of the site are all zone R3, and that's developed with single-family attached dwellings. To the east of the site, you have some single-family dwellings. There's a bed and breakfast directly east of the site, and also east of the site on the opposite side of Old Mill Road is a 50-acre parcel that's zoned conditional zoning institutional. That's a major assembly use that is a youth camp. As far as zoning history in the area, there's been very limited zoning history. From review of the staff's records, there was a special use permit that was approved in 2011 for this abutting parcel to allow a bed and breakfast use type. That was in June of 2011. I would also note this conditional zoning institutional property was rezoned in 2017. There's been an existing youth camp there at Church Mariatha for several years. That zoning proposal allowed expansion of that facility, and that was approved to allow conditional zoning institutional use to allow that use type. The applicant is requesting to expand an existing major and minor school use on the site. The development ordinance classifies a school as any educational institution that provides elementary or secondary elementary education. Accessory uses may include offices, play areas, cafeterias, recreational and sports facilities, auditoriums, and before and after school care. The development ordinance notes 2 types of school, major and minor. A major school will be any high school, so any school that has a high school student would be considered a major school. A major school would also be any middle school that is designed for more than 800 students. And a minor school would be any elementary or middle school with less than 800 students. Regardless of whether a use is permitted by right or requires a special use permit, there are specific standards for a school. Section 4.3.3 of the development ordinance notes that a school must have frontage and gain primary access on a street classified higher than a residential local street. This locational standard is being met as Old Mill Road is classified as a collector street. The second standard is no access from a residential local street unless it's a corner lot that has frontage on a thoroughfare. Well, that standard doesn't apply because this site is not located on a corner lot. Also, I would note the comprehensive plan, the 2045 comprehensive plan designates this site and the surrounding area as a suburban neighborhood use type. That place type is envisioned for low-intensity single-family dwellings up to between 3 and 7 units per acre. But the comprehensive plan also notes that public institutional uses such as schools and religious institutions are also noted as permitted secondary uses. Furthermore, under the current R3 zoning district, it notes complementary uses such as open space, schools, religious, and recreational uses are allowed. Included in your staff report's transportation information, the site currently has an access point from Old Mill Road. There are 3 residential streets that stub into the eastern portion of the site. There's a stub street here, right there, and right there. The applicant has included in their special use permit conditions that access will be from Old Mill Road using the existing access points. The Transportation Department has noted that a traffic impact analysis would not be required at this time. They have provided information that this would only be required if that use generates more than 150 trips during either the AM or PM peak hour. Included in your staff report is a transportation table that notes that would only be triggered if the school or any school has more than 184 students. At that point in time, you're looking at over 450 daily trips, and the PM or AM peak hour having 149 vehicles. So if you have a situation with any school over 184 units, that traffic impact analysis would be required. I would note this proposal will have an expansion of this facility in 4 phases. At phase 4, this facility would have more than 184 students, and the applicant has offered a condition that before proceeding with submittal of any land development approvals for phase 4, they shall seek determination from the Director of Transportation regarding the necessity of a traffic impact analysis. If in the event a TIA is required by policy, the owner shall seek approval from the Transportation Department as far as that traffic impact analysis and the location design of any improvements. As far as the specifics of this request, the site is addressed as 815 and 829 Old Mill Road, consists of 2 parcels, approximately 16.3 acres, lying along the north side of Old Mill Road. This site is currently developed with a 10,250 square foot facility, and they're operating a private school grades K through 12, and they've been operating at this location since 1999. This is proposing to expand that facility, but that does trigger this special use permit. The Piedmont School is a private school that focuses on students with special learning disorders or special learning needs. The current enrollment is between 80 and 100 students, and they're seeking to expand their facility to accommodate additional students. And they have submitted, and as an exhibit in your report, a phasing plan. This is a copy of the phasing plan that has been submitted. That's part of their special use permit, and they're proposing a 4-part expansion. The current school is this area that's highlighted in gray. That is what is existing on site now. Phase 1 is that area highlighted in yellow, and they're proposing at about 2,100 square foot building addition in this general area. Removal of two mobile classroom facilities. Clearing this northern portion of the site to allow installation of an athletic field. There will also be clearing in the southeast portion of the site to allow expansion of the parking lot and widening of the entrance drive for on-site queuing area, and clearing the southern and southeastern portion of the site for a stormwater control device to meet the City of High Point stormwater control requirements for any new impervious coverage. Phase 2 would be for this area highlighted in blue. That is an approximate 7,500 square foot building expansion. Phase 3 is this area highlighted in green. That's a 12,000 square foot building expansion, which includes a gymnasium. And phase 4 is this area highlighted in pink for a 3,000 square foot building expansion. The applicant has included in their special use permit conditions regarding enrollment of the facility. And this is a summary of information that's in your staff report. Now, currently, 80 to 100 students. Per the North Carolina Building Code, total occupancy, that's students, teachers, or any support staff, up to 200 people. Currently, there are no limits on student capacity. The applicant, as you can see, has noted in phase 1, they propose to increase their student capacity to 155 students. Within phase 2 and 3, they're going to keep that, and they've offered a condition that phase 1, 2, and 3, maximum enrollment will be 155 students. Phase 4 was their final phase of build out, where they would reach their approximately 34,900 square feet. They're looking at up to 200 students, and they've offered a condition that at phase 4, the facility not exceed 200 students. Now, although the applicant has a specialized educational curriculum, in review of this proposal, staff did not take that in consideration. Staff looks at this as any specific school can go in this location. If this school becomes very successful and they have to find a larger facility someplace else, another school can move in. So staff, in developing conditions and working the applicant, took the position that this is not just for this school, it's for any school. So we want to ensure that there would be compatibility regardless of how a school is going to operate on the site. And with that, staff had negotiated with the applicant conditions to address those concerns of compatibility. You have in your package the detailed conditions, but just in summary, the conditions of this special use permit, and these conditions run with the land. So whether it's the Piedmont School or another school in the future, they will be bound by these conditions unless they come back through for a new or amended special use permit approval. The use is for a major minor school. There's establishment of a phasing plan, which you just saw, and maximum enrollment at phase 4 would be 200 students. They've offered a condition to prohibit high-mast lighting fixtures in their athletic fields, any type of lighting that would be over 35 feet. They have offered a condition to prohibit that. And there's a condition to maintain a type B opaque landscape yard around the rear northern boundary of the site. They've also proposed a condition that limits access to one point of access to Old Mill Road. And they've also offered a queuing plan to document how, as this facility expands, they would be able to meet the Transportation Department's queuing requirement. This is an exhibit that's part of your staff report that in phase 1, which is this top area, 664 linear feet of queuing is required, and that's the area highlighted in yellow. And they've noted that they have sufficient land area to provide 984 linear feet of queuing in phase 1. In phase 2 and 3, the location of where they would start their queuing has changed, but they have documented that 664 linear feet of queuing is required and that they will be able to provide at least 813 linear feet. And at build out at phase 4, 809 linear feet of queuing is required. And they've documented with this exhibit that there will be 813 linear feet of queuing. Finally, I would note for those members of the public, there's a condition regarding tree removal and grading of that phase 1 area where they're going to do the athletic field, and also grading of the parking lot, grading to show their stormwater control device. We did note in the zoning conditions that with completion of final engineering documents, there may be some shifting of configuration in those areas, but they cannot go outside those areas. For example, where you saw the stormwater control device, that may move around as they do their final engineering, but it can't go outside that area that was designated. Also, there is a condition that City Council may approve a 30% expansion of the land area without a hearing, subject to receiving a report from the planning director that the request meets standards for a minor change. Just to make sure there was no confusion as to expansion, the staff and the applicant have negotiated conditions that, 1, this expansion only applies to the general area of an individual phase. So, for example, if during phase 2, it has to be in that area generally noted as phase 2, can't be on the other side of the site. You must meet the standards of the R3 district, so you could not submit a minor change saying, I want to change the setback requirements. You must meet the R3 zoning district standards. Also, you cannot encroach into the perimeter landscaping area, and you cannot transfer to another phase. In other words, you can't bank that square footage. You can't say, I want to use a 30% from phase 1 and put it in phase 4. You have to use that in your specific phase, just so there's a clear understanding of how that expansion, if there is such a proposal, works. I would just close by noting, if approved, these conditions are binding on the current and future land owners. These conditions run with the land, and if there are any proposed changes, they would have, that property owner or any whoever is in control of the school at the time would have to seek an updated amendment and go through this formal public hearing process. That's a summary of the staff analysis. Before I pass this on to Nick for the review of the findings, are there any questions of staff at this time?
Are there any questions from council for staff?
I have a couple.
Councilmember Hartman.
So what does type B opaque landscape mean? I have no idea what that means.
One
I mean,
moment,
is there like a
please.
picture I can see?
I do not have a picture, but that is the required landscaping when you have a non-residential use, such as any non-residential use in the R3 district when it butts the residential use. That type B is a semi-opaque landscape yard, average width of 25 feet, minimum width 20 feet, maximum width 40 feet. It requires 4 canopy trees every 100 linear feet, 6 understory trees every 100 linear feet, and 25 shrubs every 100 linear feet. The applicant could maintain or use existing landscaping to get credit. They get credit for that. But they would have to have a landscape architect document what's there, what they're preserving in order to get credit for it. I would also note, under that Type B standards, if a 5-foot opaque fence is installed, it will allow that average width to be reduced by 5 feet.
And the other question I have is, you can't have lights around the field that are taller than 35 feet, but does that mean you can have lights surrounding the field less than 35 feet?
Yes, the intent was not to have the high mast, or you may see at athletic fields, 100-foot tall athletic lights, to limit impact on adjacent neighbors. But for public safety standards, staff agreed to allowing a condition that they not exceed 35 feet. So you may have to have safety lighting along sidewalks and so forth. But the intent was not having the, if you've had a chance to visit the Piedmont soccer fields where they have the high mast outdoor lighting, the intent is to not have that to limit impact on adjacent residential property owners.
Okay, all right, thank you.
Mr. Shannon, just on that last point there, Ms. Mayor Jefferson, you mentioned the 35 feet. Where is that in proximity to a traditional street light that we may see?
I would estimate a traditional street light is near that foot. I don't
Yeah.
haven't measured one, so I can't give you a definitive.
Sorry to put you on the spot like that. Asking you. And any other questions from staff, from council for staff?
Yes,
Councilman Andrew?
Councilman Andrew, has there been any, maybe we'll get to it later, but for traffic going eastbound, making a left onto this property, has there been any impact on like traffic being backed up, waiting to make the left to go on,
I mean, currently, or
well, currently and in the future, right?
I do not have that information. I would refer to Mr. Greg Venable. I would just note, as was stated in the staff report, the TIA trigger would not be hit until phase 4. Okay.
Mr. Venable, if you'll step forward and just state your name for the record and affirm you've been sworn in.
Greg Venable, Director of Transportation for the City of High Point, and I was sworn in earlier.
Thank you.
Councilman Andrew, we don't have any issues or any concerns with the traffic currently turning there. So as Mr. Shannon said, once it meets the threshold for a TIA, one will have to be done, and then the applicant will be required to mitigate any impact at that time.
Thank you.
Mr. Venable, while you're here, can I just follow up on his question?
Sure.
And I want to make sure I heard Mr. Shannon correctly earlier. The school has less than 184 students. And so at the time, I think I heard you say it didn't require the TIA at that time, but phase 4 goes up to 200.
Correct.
So before they go from phase 3 to phase 4, they will have to do a TIA at that time?
That's correct.
And if they do the TIA, what does that then trigger if the TIA says something?
So it depends on what, so they'll have to mitigate their impact, whatever it is determined at that time, what the TIA will determine what their impacts will be. They will have to do improvements to mitigate that impact. So that could be turn lanes, anything like that that would mitigate their traffic impact on the roadway.
Can I ask this question, and not to put you on the spot in terms of being able to forecast what will happen here, but you say that there are some things they need to do to mitigate that should it trigger the TIA. If, let's say, we find out they've got to put in the turn lanes and maybe put in turn lanes that's not plausible for some reason, does that then mean they're not approved to go up to that past 184 mark?
That's correct, yeah.
Does that then mean they're not approved to go to phase 4, or they're just not approved to go past 184 in terms
They
of
would have,
occupancy?
so they would have not be approved to go whatever that impact would be. So if there were, our threshold is 184. What our impacts for a turn lane are a lot less than that. There's some other things that have to be considered when you're looking at turn lanes as well. That left turning and right turning movement, the peak hour trips, the number of trips in the peak hour. So that threshold is quite a bit lower, but for actual turn lanes. So it would depend on what the impacts are and what the improvements were determined at that time. So.
And so I just, sorry, this may be semantics here. Phase 4 is a construction thing in terms of physical improvements to the building or physical expansion to the structure of the building. But enrollment is a different thing. The expansion of the structure is to accommodate enrollment, but would they be allowed to do the structural expansion? And if they say, I'm not going to increase enrollment past 184, could they still do the structural expansion?
I think there's conditions in there for the amount of students they can have. So.
Yes, Mr. Mayor, Nick Tosco, on behalf of the city staff, I did want to point out the conditions that Mr. Venable is referring to. They are in your agenda packet. To answer your question, it is the Phase 4, when that occurs, that the construction can be done, and then a determination needs to be made by Mr. Venable first as to whether a TIA would be required based off the enrollment numbers. If the enrollment numbers hit, then based off the way we drafted the conditions, then a TIA will be required. But to answer your question, the construction can be done without a TIA.
I see. So construction could be done without TIA, and then if enrollment goes up, they do the TIA. And if TIA, nothing's plausible, enrollment doesn't go above 184, basically.
Correct. And
Thank
there
you.
are no impacts currently that would cause any improvements at this time.
Okay, thank you for that. And any other questions? I want to recognize Councilmember Moore. I think you had a question earlier.
Yes, Councilman Moore, Mr. Shannon, the stub streets you referred to,
Yes.
that are there, did I hear you say that there's nothing in this that, they're not requesting that be used for ingress, egress, but is there anything in the future that could trigger that?
I would note that they are remaining as access for emergency purposes. So if for some reason emergency fire, police personnel have to access the site through that, there can, but it's not for the general public or the parents taking their students to the school. If there's a proposal to use those stubs for that manner in the future, the applicant will have to seek a new special use permit, go through the same process of a special use permit evidentiary hearing to determine if that would be appropriate.
But as it currently sits from my visual of the picture here, the stubs there, they always are on street, but they're bounded by forestry at this point. So the way I see it, so I mean, they're not going to be able to use it unless they construct it, correct?
As far as the access drive into the site,
Correct.
that is correct, but the special use permit conditions would not allow that.
Okay.
I'm sorry, Mayor Pro Tem Holmes, I just want to follow up a bit. So what you're saying is that the current special use as requested wouldn't allow them to construct the stub streets?
The stub streets are in place now.
Well, I'm saying,
They could not construct a driveway
A drive.
access for the
Access.
stub street into the site.
Right.
The condition notes one point of access, and it's to be from Old Mill Road.
Is there anything in the future growth that would trigger the necessity to create that? And can they go to their capacity with one entrance of egress and entrance from Old Mill?
That's how the conditions are structured, and that's what we evaluated far as stacking, that they can meet their on-site stacking demands without any additional access point, just using the Old Mill Road access point.
And that would be in place even if this school left and another school entered?
Correct. These conditions run with the land.
Okay.
Any other questions from council for staff? Does the applicant have any questions for staff? Let the record reflect the attorney for the applicant indicated that they do not have questions for staff. Do the Barkers have any questions for staff? Mr. Vaughn, if you'll come forward. Thank you.
Mr. Shannon, did I send you a letter in July and meet with you with regard to this project?
Yes.
And I sent you by email and U.S. mail, is that correct?
Yes.
And this matter said, please keep this firm.
Shannon, can you come closer to the mic,
Grab
please?
that thing. Please keep this firm informed over any new developments. That was in July. Did you ever write to me and keep me up on any new developments in this?
We had talked by telephone, and I noted to you that As new information comes available, it's loaded onto our online platform that anyone can review.
Did you ever keep me informed of any of that, as you said you would?
Just
Yeah,
that
to answer the
conversation, that any new information will be uploaded onto our online permitting
So
system.
you had no further communication, even though we said we had opposition to the Piedmont School phasing plan, and you would keep us informed of that?
Our only other conversation was the continuance. You had called and wanted to know, will this case be on the October 21st meeting? I noted that it would be on, but it would be continued to November 18th.
But you and no other staff, even after this letter, had any type of communication with us, is that correct?
Correct.
Exception noted.
Noted. I would like to ask a follow-up question there, and actually, I don't know which attorney I'm asking the question to, so just for the record. Sorry. My question is, what are we legally bound to do in terms of how we communicate regarding notifications and updates of that nature?
I think Mr. Tosco will speak on behalf of staff.
Okay, thank you.
Yes, Mr. Mayor, and I would like for Mr. Shannon to answer the question since he's the one providing testimony.
Okay.
If you want to come forward. Mr. Shannon, can you tell us, are you aware of anything in the ordinance that requires you to apprise people who send you a letter of all the different manipulations and variations of a special use permit or rezoning? Is there any requirement for that you're aware of?
No.
Okay, and can you tell me, are you aware of whether or not the attorneys for this matter, meaning your attorney, myself, or the city attorney, have been in contact with the attorney for the Barkers?
It's my understanding there is some contact as far as procedure as to how this hearing would be conducted.
Correct. Okay, yes. Does that answer the question?
And-
Okay.
Any other questions from council regarding that point that we just asked about? Okay, thank you for that.
Follow up cross.
Mr. Vaughn, will you come
I
forward?
know this is not the usual procedure, but it is my duty. Will you come and point with this pointer where those lights will be placed, and if you would note my client's property on the right? And how close is that?
Your second question first.
All right.
Your client's property, I believe, is right here.
Adjacent to the property,
Yeah.
correct?
Yes. There has been no final engineering drawing submitted that shows that information, so I cannot answer the exact location of if or where any lighting will be placed on the site.
And how high are these lights in this room?
I will only be speculating, sir.
Are you speculating on the other also?
I don't understand your question.
How are you speculating where you're going to put the lights?
No information has been provided. That is typically done at time of final site plans being submitted.
No further questions. Exception.
Exception noted. Any further questions, council applicant or Barkers for staff?
No, Mr. Mayor, from the applicant.
Okay. Let the record reflect there are no further questions. This time, we'll transition. The applicant may now present evidence and legal arguments. As a reminder,
I believe
sec.
Mr. Tosco is going to finish up the staff report with the findings.
Yeah, Mr. Mayor, I'm just going to reserve the part about the findings at the closing statement.
okay, perfect. Thank you for that. The applicant may now present evidence and legal arguments. As a reminder, any evidence and argument must focus on the applicable standards, documents, and other physical evidence referred to or used by witnesses will need to be entered into the record, and a copy left with the council for that purpose. Before you begin, just please state your name and who you're representing.
Yes. Good evening, Mr. Mayor and Council. My name is Will Quick from the Brooks Pierce Law Firm. I represent the Piedmont School tonight, along with my colleague Otis Walker, who may give me a hand here in handing some things out. If I could get someone on staff's help to make sure I get my stuff up, I didn't want to mess this up before I get going. Just advance advance it with the mouse? Or?
Yeah, if you want this one right here.
Okay, great, all right. Okay. Thank you, I appreciate that. Again, Council, Mr. Mayor, thank you all for having us tonight. As I said, I'm Will Quick, representing the Piedmont School. And before I get going, there are a couple folks from the Piedmont School that I want to make sure I point out. All of these folks were sworn in. We have a lot of other folks here who weren't. But Corey Mackel, who is the head of school. Corey, if you'll just stand up and let everybody see you there. We have Holly Myers, who is the president of the board of directors for Piedmont School. Then Stan Gordon, who is the former president of the board and began this project with us, along with, Rick Brown from Boomerang Design, our architecture team. We've got Richard Alexander from Fourth Elm Construction, who's involved for that portion of the project, and then Eddie McEldowney from Davis Martin Powell Engineering. And so all of those folks were sworn in this evening and are available to answer questions. I do not intend to bring them all up here and go through that, but if anyone has questions, I may call on one of them for their particular areas of focus. In order to try and move this along, one of the things that we spoke with Mr. Tosco about in advance was submitting a series of affidavits to back up what I will then go through summarizing in presentation form. And so we have an affidavit from Ms. Mackel as head of school and one from Mr. McEldowney, who has put together the phasing plan and the queuing exhibit that Mr. Shannon went through a minute ago. And so the affidavits of each of them go through what I will summarize. I would ask that council accept those into the record as evidence that I can summarize. And we have copies of those for each of the members of council and for Mr. Tosco representing the staff and
Excuse
Mr.
me.
Vaughn
Will you-
representing the Barkers.
Will you give them to the clerk, please? No.
If Mr. Walker may approach and bring that to everybody, we'll let that happen. And I'd love to get one to Mr. Vaughn here in a second. But
Thank you.
And as council flips through those, I'm going to apologize. I got Corey's name wrong. It is Makel, not Mackel, and she corrected me as she should. So I will get that right from here on out.
Let the record reflect.
So council may obviously take as much time as you would like flipping through these affidavits. I will go through, if you all are willing to accept these into the record, and summarize what's in them in presentation form. I understand that again, if there are questions, we can bring either of these individuals up or any of the others that we have. But we tried to do this in a way that would present evidence, competent evidence, in a summarized form.
If you like to, you say you have a slide deck, do you want to go through?
I do, though I would love, if, Mr. Mayor, if you all could accept these into the record. And of course, if Mr. Vaughn has any comment on this, he's welcome to do so at the appropriate time, same Mr. Tosco here.
Okay, let the record reflect that we accept these into the record. Duly noted. Let the record reflect that Mr. Vaughn for the Barkers objected, and the objection is noted. Thank you.
Great. Thank you, Mr. Mayor. So what we're looking at here is an aerial photograph, obviously, of the Piedmont School. And just so everyone, I'll orient everyone, because some of the slides we go through will sort of have relevance to where we're looking from. So if you're looking at this photo, north of the property is to the back there where you see the wood line behind the building here in the picture, which is the current structure of Piedmont School. South is towards the bottom of this photo, going out towards Old Mill Road, out the parking lot towards Old Mill Road. East is towards the playground that's showing here, and then that is the side, I'll point out, where the Barker's property would be located to the east. And then west is towards the side of the building that is where the modular unit there is shown. This photo is a little bit older. I believe we have 2 modular units now. That's back when there was only 1. As Mr. Shannon noted, we're at 815 Old Mill Road. The primary parcel is about 15.26 acres. There's an additional parcel under common ownership, a little over 1 acre parcel. This is a major minor school use, and it would be a phase expansion of what is there now. The zoning is currently R3, and it would remain R3. This is no request for a rezoning, as noted earlier. I'll point out that in the R3 district, it acknowledges that complementary uses include schools and other similar types of institutions. And as was noted earlier, this requires a special use permit in the R3 district. The Piedmont School has been on this site for quite a while, but it was in existence even prior to that. So the school was founded in 1982 as a half-day program for attention deficit disorder and learning disability students. It was founded and began at the St. Mary's Episcopal Church here in High Point. It then moved at one point to the B'nai Israel Synagogue. A little bit of irony in that the special use permit that you all heard last month was for that facility where the Piedmont School actually began. So kind of an interesting coincidental connection there between this and your last meeting where you heard one of these. So for the first 14 years, it operated as a half-day. And then in 1996 is when it moved to the B'nai Israel Synagogue and added a full-day program. In 1999, in August of 1999, the current just over 10,200 square foot facility that they're in was completed and was moved into in 1999 there on Old Mill Road. That was 45 students at grades 3 through 8, with primary grades K through 2 being added later, and then a high school program was added in 2014, all within the footprint of the original facility that was constructed primarily for students grades 3 through 8. I'll note, because this was brought up in Mr. Shannon's presentation, that because of the type of student that the school serves, it intentionally keeps its class sizes low in order to serve those students best. And so while you saw enrollment numbers that might have been higher, potentially that the building could take, it has never been the Piedmont School's intent, and while they're there, they have no intent of ever reaching those maximum numbers, which is why they're willing to accept these enrollment capacity numbers that we've proposed. So the school is facing a number of challenges right now, and they're summarized here. Because of the way the school has grown organically with originally 3 through 8, then adding K through 2, and then later high school, they don't have dedicated spaces for each of those types of grades and the needs of the students in those grades. The slide here notes including bathrooms, and so you might imagine kindergarten and second grade students are using the same bathrooms as high school students, and that's not always ideal. And so one of the things that expansion will allow us to do is to designate space within the facility to serve certain grades. Another issue with space is having dedicated space for art, music, and science. I see there are a couple folks here that were at our Citizens Information meeting over the summer, and they got to see that there are curtains up and things to move around so that you can use spaces that are in the current facility as creatively as possible. But having dedicated space for art, music, and science would be really important for the school moving forward. You saw one of the modular classrooms. There's now a second modular classroom, so not ideal to have those. Currently, there's not a dedicated space for dining and library, and so being able to, again, have that dedicated space for it. And then I'll go through, you'll see this in some of the further slides, but there's no gymnasium and no dedicated outdoor space right now for athletics and physical education for the high school students. That, again, is particularly important as they compete in certain leagues, but they have to use other facilities around town in order to have those competitions or even practice in some instances. And then finally, places for parents to come and gather and see assemblies, the kinds of things that if you've ever had children, you've spent time doing with them. The school just doesn't have the ability to do that now with its current enrollment. So this was submitted as part of our original application that was submitted in July, on July 16th of 2024, and it was part of what we showed at the Citizens Information Meeting. It is early. It is, so why it says for informational purposes there on the bottom, but it gives you a little bit better idea of what the interior portion of the project would look like. This is not part of our special use permit conditions or part of the exhibits to the conditions, but again, it'll give you some idea here. And so you can see in gray is the current facility at just over around 10,200 square feet. And so that is basically what it is being used as now. The common space is kind of a flex space that meets many needs there in the front of the drawing. And then there are classrooms spread throughout. Phase 1 would be the yellow, same coloring that was used earlier. That phase 1 is going to be eventually for the K through, phase 1 is high school? Right, okay, yeah, I got it. Okay, so to make sure I get this right. So some of this will move around as time moves on. Originally, phase 1 will be dedicated for high school, but ultimately it will move into where some of the lower school programs go. When those phase 1 yellow goes in, the modular units that we'll look at in a second will be removed, and so that'll allow dedicated space. You'll see a door there between those and a separate set of bathrooms there for the early phases. Then phase 2 and 3, so phase 2 is the blue at the top. It's going to be the new lobby, common area, and we'll have more bathrooms and some dedicated space there for things that are now being done in multi-use space. There'll also be science classrooms, as you see, if you look at the kind of bottom of where the blue is going into the gray. Those will be science classrooms dedicated to things like biology and chemistry and things that the high school students need. And then phase 3 will be a gymnasium, art space, and music space. And then finally, phase 4 will be additional classrooms, which will then allow the high school students to move to that portion of the building, which is further away from where the K through 8 sort of will be in the current structure, and then what is yellow in phase 1. So that's why the phasing is in place, because it gives us the ability to make some early improvements and designate some space. But then as time goes on and the funding's available to do these additional phases, the building will kind of be reconfigured within its footprint. Again, only for informational purposes. It's submitted as part of what we submitted in July, and so it's part of the agenda packet and record today. This gives you an idea of what it will ultimately look like. And so you see, again, same coloring. The gray is the current facility. The yellow is the initial phase 1. Blue would be the lobby and science spaces, common area in phase 2. The green is the gym, art, and music space in phase 3. And then the pink at the back is a final set of classrooms as phase 4. As I mentioned earlier, we held a citizens information meeting in the summer per city requirements and mailed out notice to everyone notice was mailed to everyone within 300 feet of the property. And we ended up with 20 people in attendance. We had our entire project team that I named earlier there to present and answer questions from the community. Our summary report from that meeting was included in our initial packet submitted in July, and as part of this submittal. And here's just a summary of topics that we discussed, many of which came up in questions to staff, and I suspect will come up to us. Environmental impact around things like the stormwater control mechanism. I have lighting on here twice. I just noticed that. Lighting came up, and it did come up at the Citizens Information meeting. How the outdoor facilities would be used, kind of time of the day they'd likely be used, what the plans were around the clearing and the buffer yard, what our enrollment plans were, traffic impact, and when originally, I'll note that we had proposed an initial condition related to installation of a sidewalk along Old Mill Road. We ultimately have removed that condition in talking with staff and reverted back to what's required under your ordinances, which would mean that once we hit a certain trigger point, we would be required to work with staff about installing a sidewalk. So we're not trying to push that out at this point as we initially suggested. And then project timeline came up at that meeting as well. It was hard to answer some of those questions, but we did our best. All right, so let's now drill into some of the phasing plan and what we're looking to do. Before I do that, I'll note, we've had multiple meetings with Mr. Shannon, and we submitted ourselves to an informal TRC meeting back in the spring to go over, concerns from different departments and consider, their input into the process. And so we did that in April and incorporated some changes into our planning prior to that citizens information meeting. So we have been around the block. This is the same phasing plan that you have seen already, so I will not spend a ton of time going through this. We're going to look at some portions of it individually. Here I'll note just while we're looking at the full plan, you can see around the exterior the Type B buffer yard, and it's really hard to see on this slide. We may be able to see it in one of the others, but the note that is in the buffer in 3 places, so on the east side, on the north side, and on the west side, notes that we may try to meet those with existing vegetation. And you'll see that the existing vegetation is much denser than what a Type B yard might currently require. Our goal would be to not have to remove that and meet it in that way, as Mr. Shannon pointed out, is possible under the ordinances. I noted the sidewalk issue, and so you will see Old Mill Road is runs up in the corner of this drawing, and you'll see what is a sidewalk, but it is not included as part of our phasing. We recognize that we may eventually have to install a sidewalk, and have shown it here, but it's not part of the phasing because we'll wait on when that's triggered by staff review. All right, now we'll go look at, why did that not work? You were supposed to be looking at a overlay of our phasing plan on a GIS map. It appears not to have shown up in the version that got through here. But if you look, if you have your agenda packet, it is in your agenda packet at if you look at page 145 in your agenda packet, what ultimately we wanted to show you is there. And it simply shows that the orientation of the property in relation to the surrounding community. And in particular, I just wanted to point out with this that there is dense tree buffer in that back area where the field will ultimately go. And again, we want to try to do our best to meet the requirements of a type B yard by leaving what is there as much as possible. All right, I'm going to go, let's see, we'll just go forward and skip that. As noted, we submitted and worked with the city on proposed conditions. It's 4 pages. Not asking you to try to read that here. We'll go through what some of those are, but again, this is part of the packet we've submitted and is part of your agenda. This drills down to the front portion of the property. So again, as noted in phase 1, this portion of the property will be entrance drive upgrades in the form of a sidewalk. There's currently not a sidewalk along the entrance drive, and so ultimately, if we have to connect to a sidewalk out on Old Mill Road, having one here, we want to go ahead and take care of that in phase 1. You see in the top of the drawing shown there, the parking lot zoomed in. There's a current parking lot that is in a portion of where this is, but we'll expand the parking lot here. And then you see at the bottom of this is where the stormwater control device will be installed. That stormwater control device ties into, and you can kind of just see it here on the edge of the property at the bottom, Brandomere Drive within the Blairwood Estates. And there is currently stormwater control that is intended to move water from our site into the stormwater drains that flow under Brandomere Drive. Obviously, this property was constructed in 1999, and things have changed, and time has gone by. And so, in doing this project, one of the things that questions we've gotten from citizens is, will it be better? We've seen some problems before. Will be required in doing this to meet current standards under city ordinances for your stormwater control. And so what goes in there will inevitably be better than what was there in 1999 and its current effectiveness. Along the entrance drive, it is not highlighted in any way, but you see a little arm that sticks out there about halfway along the entrance drive. That's the current service area where the dumpster and recycling site is. We have proposed a condition that remain 100 feet from any residentially zoned property, and that does meet that requirement where it is. And so regardless of whether we ultimately ended up moving it, we will never move it any more than 100 feet from a residential property. We've got a condition around access from Old Mill Road with no additional accesses. So this will be the only access. We're agreeing to that condition. And then as I mentioned, or was mentioned by Mr. Shannon, we would have, before moving to phase 4, a requirement that we at least go to transportation and determine whether a traffic impact analysis was required. At that point, ultimately, if one's determined not to be required, we could move forward. But it's possible that we could still trigger that at some point in the future. That doesn't go away. The requirement to do a traffic impact analysis would not necessarily go away just because it wasn't required at that phase. We're just saying we will emphatically come back at that point and determine whether it is needed by applying to transportation. So again, to give you an idea, this is the current entrance statement and view entering the Piedmont School. As you see, there is no sidewalk along that, and so we will be installing a sidewalk along that. So the left is looking from Old Mill Road into the Piedmont School. The right is sort of leaving the back of the parking lot for the Piedmont School and heading out. You can kind of see here on the left and right, there's some gravel areas where parking is currently a little bit, we have some parking issues, and so particularly for the high school students, we've got creative ways to meet that need right now, but a sidewalk will go in along there, and then as the parking lot's expanded, we'll have more parking available. This moves to the center of the site, and in particular looking at what's going to happen in phase 1 along the center of the site. On the bottom, you see a gravel drive that starts at the end of the existing parking lot and then swings up sort of to the corner of that image. That will be for access to the athletic field for any vehicle that needs to get to the athletic field, including, for example, an emergency vehicle if someone were hurt. Ideally, we would not need emergency vehicle access from Sandalwood Road, which I just realized, I guess, can I use? Mr. Shannon had a neat way of showing a little circle. Do you know?
Oh, the pointer.
Bottom left. All right. Oh. Okay. All right, cool. There we go. So this right here is Sandalwood Drive, and there is a gate right here currently, and we do not intend to open it or use it, and that's the condition we're agreeing to. The idea here is that any emergency vehicle that needs to access the athletic field could use this gravel drive that we will install along the property. Obviously, if law enforcement or emergency vehicle needed to use it, ultimately I think that would be their decision, but this is what we intend, and we will not open that. The modular classrooms are currently right here, and those will be removed as part of phase one, and then this is the interior portion that we looked at earlier with the addition that will initially serve high school and then later the lower grades.
So the modulars will be moved, this is Councilman Moore, or can I ask a question as we go along? The modulars will be moved and replaced with building.
And I'm going to do what Mr. Tosco did, and so I would, Mr. McEldowney, would you mind coming up and answering the plans with respect to the modular?
Yes, my name is Eddie McEldowney, and I'm an employee of Davis Martin Powell and Associates in High Point. It is my understanding that when we build the new building, once it's completed, the students will move into there and the modulars will be removed.
Will you just affirm for the record that you were sworn in, if you don't mind?
Yes, I was sworn in.
Okay. Councilman Moore, did that get your question answered?
Yeah, they're going to remove the modulars and build the concrete facility there.
Okay.
Okay, and so as part of the affidavits, what we also say about this area is that the playground that is currently on the east side of the facility will actually move to where the modular units are now. That's our plan. It's not a condition or a portion of this, but that's ultimately what we'd like to do, because when the parking lot goes in that area, that's where the playground currently is. We've got to move things around.
Thank you.
Mr. Mayor, can I ask a quick question?
How far are we from your presentation being done?
A little bit.
Really, really close?
Nah, I mean, I don't have too much longer on this portion.
Okay. Is it a quick question, Councilwoman?
Yeah, I just wanted to clarify. I thought it was asked multiple ways in the last portion of the hearing about the access points and about those roads, that there was vegetation there, but now we're learning there's already road access with a gate?
Yes, that I think was mentioned earlier.
So what I'll point you to that might help that, Councilmember Cook, in your agenda packet, if you have it available, if you go to page 219, this is a portion of our appraiser impact study, and it shows an image of the current gate that's there. It is wooded, but there is a gate.
Mm-hmm. But this is showing a road. I guess I'm just not clear what this, I don't know what you would call this. It's not there currently. Okay. But there will be a street there.
There is no street here.
Or, I'm sorry, there will be a paved surface that a vehicle could drive on?
There will be no paved surface here. There is a pavement ends right here. It is currently paved to the property line as a stub street as part of Sandalwood Drive and Blairwood Estates. And then there is a gate there currently that blocks access, but there is no paving between the.
But there's not trees there.
It is quite overgrown if you look at, except it's on page 219 of the agenda packet. It is overgrown, but there is a gate. You can get through it, if you could get through the gate.
Okay, we can move on and I can find that, but I just wanted to clarify because that sounded different than what we discussed earlier.
Perhaps when your presentation gets done, we'll come back to that point, so that way we can clarify that.
Okay.
Thank you.
Yeah. This just shows the modular classrooms that will be removed. We've noted that. So that will be removed during phase one. And now moving to the back portion of the property, we have here the athletic field and the clearing and grading that will happen as part of phase one. You can see better here around the edge of the field, the type B or existing vegetation. And so again, that's the goal, is that we could meet this through existing vegetation in this area that's currently wooded. The field, as Mr. Shannon noted earlier, may need to shift a little bit within the area. Ultimately, grading may not be required, or tree removal may not be required in all of the area that is yellow, but you can see what an athletic field size would look like. It may be that it needs to move back a few feet or to the side a few feet, but ultimately it fits with plenty of room in this space. And the school, for a variety of reasons, not the least of which is cost, would prefer to grade and clear as little as they have to clear around the exterior of the field. There was some questions earlier about the outdoor recreation lighting. So I want to make sure I point out, what we say about that. And so if the conditions that we've agreed to are attached to the affidavit of Ms. Mackle. And I'm just going to read this because it's part of the record here. There shall be no outdoor recreation lighting, outdoor assembly lighting, or similar athletic field stadium lighting permitted on the subject property. That's a period. And so the lighting is not going to be athletic field lighting. What it might be, this prohibition shall not apply to commonly used exterior lighting where mounted height is not greater than 35 feet above grade, whether mounted on poles, walls, or by other means adjacent to exterior walkways or structures in parking lots, along the entrance drive, or otherwise used to light areas for safety and security reasons. And so it is not field. This is going to be, for example, along possibly the emergency access gravel drive for access to the field so that you know where that is and it's demarcated. It might be, you see here on this image, there's a pathway accessing the back of the pink area, which is the Phase 4 building addition to where the field is. There may be lighting along pathways, but it's not field lighting.
Objection noted. Thank you.
All right, but we have agreed to a condition that the city can enforce around the idea of outdoor assembly lighting and athletic field lighting. So that's what I wanted to make sure was clear here. Again, another condition we have agreed to with respect to the athletic field area is that we won't install permanent bleachers or grandstands. We're going to limit this to what is essentially movable bleachers. And so there will be no, as you might see at a stadium, at a small college or something, there won't be nothing like that, or even a public high school. These are going to be movable bleachers that can be added or removed as needed. So just wanted to show you, there were some questions about the buffer yard and what it might look like. This is the current view of the western side of the property and the eastern side of the property where there is clearing. And so on the right side, you see on the eastern view, you see the very corner of the playground there along looking over to where the east is, which would ultimately be the properties of Mr. Vaughn's clients. And so that's an idea of what the vegetation looks like currently on that side. And then similarly on the western side, this is along the Blairwood Estates side of the property and what's there now. The idea would be not to have to remove this if possible. So moving to the central portion of the project, this is all stuff that we've talked about in interior parts of the building. So phase 2, 3, and 4 there are shown in blue, green, and pink. All of this would take place as construction for build-out, not development of land or parking lots or athletic fields. I won't spend too much more time on this because we've seen this a couple times. Wanted to show you all what the current parking is. This is the current parking lot on the eastern side of the property. As you can see here, it's being used as multi-purpose space, not a lot of parking going on. It is the area for basketball, volleyball, and a variety of other activities from this physical education and sort of athletic space. That'll be removed and replaced with a different parking lot, and then there'll be some additional clearing to expand that. Mr. Shannon noted the condition that we've added with respect to queuing, so I won't spend a lot of time on this. There's really nothing to add here, but that we think we have, we do have, based on the work that Davis Martin Powell has done, space to get the cars on the property. And I'll just note that while we intend to, in phase 1, you'll see the drop-off is currently here, which is the existing building, because obviously at phase 1, there will be no gym. There will not be, or there will be no common area and lobby here yet. So the only place to drop off is there. That gives us plenty of space. By phase 2, the common area and lobby will be completed, and the ideal drop-off at that point is here in this new common lobby space. Again, plenty of space at this point based on the work that Davis Martin Powell's done. And then by phase 4, we're going to maintain the drop-off at the same place. We obviously are able to go up to a higher number of students. I will tell you, and it's part of the affidavit from Ms. Mackle, that while 200 students is the condition we're agreeing to, that is a very much a stretch goal for TPS. They may never get that high. Again, ultimately they're keeping class sizes low. But even if they got to that point, we have enough. And what I'll also point out is that even at that point, if there were a concern from transportation, if we had to make changes to the entrance area because of a traffic impact analysis, there's additional space in the parking lot where we could ultimately do some work to change the queuing on the property, but we don't think we'll need to do that. We think we have the space as is. All these were summarized by Mr. Shannon as additional conditions. We must comply with your local ordinances and any state and federal laws that have to do with building permits and fire safety and all those sorts of things. We could install accessory uses like fences, playground equipment, picnic shelters, those sorts of things within the area that's shown as part of essentially phase 1, the yellow. Can't be in the type B semi-opaque landscape yard. And then Mr. Shannon summarized the minor amendment and major amendments pieces that we have, so I won't go through that. I'm now going to ask Mr. Brian Crowder, who is an appraiser that we have engaged with for a market impact study, to come up. And I will ask council ultimately to qualify him as an expert, but I'm going to let him explain some of his background and qualifications first before I ask Mr. Mayor to accept him as an expert.
Mr. Crowder, if you'll state your name and then just affirm you've been sworn in.
My name is Brian Crowder. I have been sworn in. Good evening, Mayor Jefferson and council. As I said, my name is Brian Crowder. I'm a North Carolina State Certified General Appraiser with over 16 years of experience, working the entire time with the firm Hilton Crowder & Associates based in High Point, North Carolina.
You have no objections to him being an expert? Duly noted. Thank you.
Then I would, you may finish.
Yes.
All right, well,
I started my appraisal career immediately following my graduation from North Carolina State University. I've appraised numerous types of properties and provided consulting assignments for multiple property types, including single-family residential, multifamily residential, vacant land, commercial, industrial, office, institutional, along others during my career. I have the MAI and SRA designations from the Appraisal Institute, which is the largest and most recognized professional appraisal organization in the world, which both require extensive courses, exams, and experience. Some requirements that I have met to achieve the MAI and SRA designations include a college degree, extensive educational classes, including multiple advanced classes that were a week long each. Each of those required passing an exam at the end in order to receive credit. I had to pass, on top of getting my general license, an additional 16-hour comprehensive exam that had 4 modules, each of which was 4 hours long. I received credit for 4,500 hours of specialized experience. Of this 4,500 hours, 3 random appraisals were chosen by the Appraisal Institute and were analyzed, graded, and interviews were conducted on these appraisals. I completed the General Demonstration of Knowledge report, which is considered somewhat similar to a thesis paper. Every analytical section of this report had to provide adequate justification, support, and documentation. And I had to provide market data to support every adjustment made within the report, and then was graded on it before giving credit. The MAI designation has long been recognized by courts of law, government agencies, financial institutions, and investors as a mark of excellence in the field of real estate valuation and analysis, and is recognized not just in the United States, but all across the world. I'll also note I am the only appraiser based out of High Point that has both the MAI and SRI designations, and one of only a few in the entire triad. In addition, I regularly attend seminars and continuing education to be informed of emerging trends, changes in appraising, and to maintain my license. I have served in various capacities within the North Carolina chapter of the Appraisal Institute, including a regional representative on the board of directors. I am the committee chair of the Real Estate Valuation Conference that provides continuing education for appraisers all across the state of North Carolina. Most currently, I am an executive officer for the North Carolina chapter of the Appraisal Institute and was recently recognized by Triad Business Journal in the 2024 class of 40 leaders under 40.
So, Mr. Mayor, with that, and with no objection from Mr. Vaughn, and Mr. Tosco and I have already agreed to a joint stipulation, so I assume he will agree. I would like to designate Mr. Crowder as an expert in appraisal.
Having noted that there's no objection from any of the other parties, we'll go ahead and accept Mr. Crowder as an expert.
So, Mr. Crowder, if you will summarize your report and your analysis for the council.
Sure. I completed an impact study for the Piedmont School expansion on July 16th of 2024. My report totals 72 pages, including the addenda, and I understand my report was submitted by Mr. Quick in support of the application by the Piedmont School, and that the report was made available to council in advance of this hearing. The report that I completed was not an appraisal. I was not asked to place a market value on a particular house or use of land. This was a consulting assignment to determine if the proposed Piedmont School expansion would have a measurable impact on adjoining or abutting property, and if so, would that impact be an injury that is substantial? I was also asked to determine if the proposed Piedmont School expansion is in harmony with the area in which it is to be located. To reach this conclusion, I used analyses and methodologies that are taught by and consistent with the regulations set forth by the Appraisal Standards Board, which conform with the Uniform Standards of a Professional Appraisal Practice, or what is commonly referred to as USPAP. These standards have been developed, perfected, and tested over many decades, and they are changed every 2 years to conform with current lending and appraisal practices. And these standards are relied upon by every financial institution in the country for lending purposes and for real estate transactions. They are also used and accepted by all state and federal trial courts. These same methods and standards were applied to perform my study to determine whether the proposed Piedmont School expansion would substantially injure the value of adjoining or abutting properties and would be in harmony with the area in which it is to be located. In conformity with these standards, I found several schools and/or athletic facilities, some of the schools had athletic facilities with them, that were similar, and some that had the potential for a greater negative impact. These are called paired sales analysis, or the more common term is comparable sales. If any of you obtained a bank loan or a mortgage to buy your house, it is most likely an appraisal was required that has used this paired sales or sales comparison methodology. At each school or athletic facility that I studied, I found an adjoining or abutting property that had recently sold, and then compared this property to sales of similar properties within the same general time period and the same marketing area, yet far enough away that the impact of the study, school, or athletic facility would not have any potential impact. The data that I collected shows objectively how people actually choose to spend their resources as they invest in their homes, land, or other properties. This data shows homes and any other uses adjoining abutting schools or athletic facilities like this one, and even more intense facilities, are not injured or impacted measurably by the school and/or athletic facility. My conclusion here is also consistent with numerous appraisals I've completed of properties next to or nearby other similar property types over my years. The appraisal term for the use that has a potential for a diminution in value to nearby properties is called external obsolescence. It is a type of depreciation and is generally incurable by the owner, landlord, or tenant. External obsolescence can be caused by different factors, including traffic, odor, noise, environmental hazards, or visual experience. Based on the objective data in my study, I concluded that the Piedmont School expansion, in accordance with the rules and restrictions it must follow, will not substantially injure the value of adjoining or abutting properties and will be in harmony with the area in which it is to be located. Not only will there be no substantial injury or depreciation, these studies demonstrate why there would be no injury or depreciation at all. While the studies in my report focused on the impact to residential properties, as that is primarily what surrounds the Piedmont School, it is my opinion, based on market data, that other potential land uses in the area, such as other institutional uses, home businesses, multifamily properties, and temporary lodging, would be less sensitive to external obsolescence factors than single-family residential properties. Therefore, my finding of no impact to residential properties applies to all other surrounding land uses.
Mr. Crowder, thank you so much. Any questions from council for Mr. Crowder? Thank you so much.
Thank you.
And, Mr. Mayor, it may be appropriate if Mr. Vaughn has questions for Mr. Crowder to do that at this time.
We'll need you to go up.
Yeah.
Did your analysis have a bed and breakfast next to it, like the case here? And what was that study?
As I explained, I did not have one of a bed and breakfast because residential uses are more sensitive to external obsolescent factors than other types of real estate, including a bed and breakfast.
So let me understand, your answer is no, is that correct? No further questions?
And I just don't want to presume that Mr. Tosco doesn't have questions, but, okay. Thank you, Mr. Crowder. Mr. Mayor, with what you've heard from Mr. Crowder, and just to make sure we do this for the record, Mr. Tosco and I had already agreed to all exhibits, including the appraisal study, being appropriate to enter into the record. But I'll ask that for Mr. Crowder's appraisal report, which is at the agenda packet from pages 164 to 235, that it be entered as an exhibit into the record.
Any objections? Okay, objection by the Barkers noted. Any objections? None from staff? Okay. Hearing none, we'll go ahead and accept it into the record.
Thank you, and that's just the photo of the front of it. I'm going to skip past that, and here are the conclusions that Mr. Crowder just gave. I won't summarize those again, but they are included as part of our presentation with respect to the impact. With that, I am done with my presentation, but before I sit down, because Mr. Vaughn objected to the joint stipulation that Mr. Tosco and I entered into between the applicant and staff, I would also ask that council accept into the record at page 105 to 163 of your agenda packet, the application and related materials that the Piedmont School submitted on July 16th, 2024.
Any objections from staff to accept that into the record? Any objections from the Barkers? Duly noted. we will accept it into the record. Thank you.
All right, well, that's all I had. I'll come back and summarize the findings at the end in closing. If council has questions for the applicant, I'm more than happy to bring up any of our team to answer those questions.
Yeah, let's see. So Councilwoman Cook, I know, had the question from
I found
earlier.
the page, the numbers in our packet are not quite the same.
Agreed.
Yeah. So I did find it in the Hilton Crowder report on page 56 of that report, I believe. So just to describe for anyone who hasn't looked at this, so it does look like that substreet ends, there's a grassy clearing and there's a hole cut out for access. So I guess what I was imagining based on what was explained before was that the trees completely covered, but this actually looks more like an access point. But is there a lot? I mean, it's just like a swing gate that's.
Ms. Mackel, would you like to come up and
in
answer
place
that, please?
Ms. Mako, if you'll state your name for the record, just affirm that you've been sworn in.
Good evening. My name is Corey Makel, and yes, I was sworn in. So to address what you're bringing up, so there is a clearing. There's a swing gate that is locked and remains locked. We've never used it as an access point. I think when it was the building was originally built, it was put there in case emergency vehicles needed to get in that way, but it never has been used in any way.
Okay, but I guess I'm just asking because it's not quite opaque. I mean, there is a hole leading out into the street that potentially, the phase one construction, what people living on that street could potentially be affected by that. And the activities that are happening on a playground would be directly, I would think, in front of there where that clearing is, correct?
I don't believe the way the plans are drawn that, and I could let the architect and construction speak to that, but nothing would be going directly in front of that. Where the modular units are is a little ways up from that. It's hard to tell from these pictures, but they're not even close to that. So the current activity that's out there does not come anywhere near this kind of clearing or opening.
Councilwoman Cook, are you trying to verify that the standard for the opaque sort of landscape, that it will meet it based on what the drawings are? And is that what you're trying to sort of verify? And then would that opening also be consistent with that standard? Is that what you're trying to verify? Is there someone, perhaps from staff or an expert we've got here, who can give us an understanding of how that opening, whether or not it is consistent with the
I'd like to
opaque?
bring up Mr. McEldowney. He's got some background on why that might be that way.
So I think originally when the school was first built, it was used for emergency access only, but there's also utilities. We've got to extend the water line to put a fire hydrant back there behind the school to satisfy the fire marshal. And we cannot plant on top of city utilities. So that's why there's a grassy area there, so.
Does that answer your question? Does.
I guess.
Well, and I'll go back because it might help to see this, Councilmember Cook. Let me go back to, if you look here, so it is part of this, that the semi-opaque type B yard ends just before this. Now, this portion is currently wooded, and it's nothing shown here because we don't have any plans with respect to this portion of the property. It's already wooded through here. And this portion is fully wooded in the back, but it did end there, just to note that was shown.
But I guess if you follow the line from the street,
Right
it
here.
leads right to phase one. So is there anything buffering the view from the end of the street to where the construction activity, the playground activity, and other school-related activities would be happening? Is there anything else there to buffer that?
So as Ms. Mickle indicated, there's a a little bit of a hill here. It's hard to see in the grading, but if you're on the property, you're kind of looking up. I think the photo in the appraisal report was looking down.
It's hard to tell. I wish there was some more visuals of that, but I'll let it go, but I appreciate you clarifying
Understand the
that.
point. Other questions?
Yes, Mayor Pro Tem Holmes. This is for maybe Mr. Crowder can help us. And maybe also our staff. The Seven Oaks Bed and Breakfast, you said that residential is more sensitive than other types of real estate. What is the current zoning for the bed and breakfast? Does it not qualify as residential?
This is Brian Crowder. Herb, you might be better qualified to speak on that, but I can speak more on why residential is more sensitive than.
The bed and breakfast site has a residential single-family 3 zoning designation.
So it does qualify as residential. It is currently zoned as residential.
Yeah, it has an R3 zoning designation.
Okay. So could you clarify?
Yes. The reason that residential properties are more sensitive than other types of properties is because if you're buying a residential property, that's where usually you sleep, where you're there every day, where your kids might go outside and play, or your family, where shows more sensitivity on all my years of experience to external obsolescence factors than somewhere you may work or somewhere you may visit 1 or 2 times a year or somewhere you may just go during the day. So that's why it's much more sensitive for residential. That's why you normally see not as many residential uses right near a heavy industrial zone site or near things that present those types of factors.
Can I ask a follow-up question related to that? But wouldn't a business that I would think relies on reviews be sensitive in that way also? Because if somebody happens to come on the night of a soccer match or lacrosse match happening right there adjacent to the property and leaves a bad review that there was noise, wouldn't that put that
Yes, I agree. Any property type can be sensitive to an external obsolescence factor, regardless of whether it's a very heavy machinery, loud facility, or a home on 10 acres. But residential is more sensitive than other properties, just like you see hotels can be right near airports with airplanes that fly right over them. So you'll see lots of different, usually residential is more sensitive to external obsolescence factors than any other type of real estate.
Council, one sec. So I think there's a couple of things we probably need to hear first. I think before we sort of begin to argue their case, we should hear from the Barkers to hear what their case is about some of this. And I think there is a question here about events at night that we've not heard from Ms. Makel, but I think it is important first, let's hear from the Barkers about their property impact, so that way we can be very clear about what they're stipulating to be the impact on the property. And then, Mr. Crowder, if you'll hang around, we may want to come back to you at some point.
Yeah.
Okay.
Let me just understand clearly for the record, in all of your studies you did on this case, you never found a bed and breakfast example like this. Is that correct? That's a yes or no question.
Yes.
Okay, where was it?
No, I'm sorry, I misunderstood your question. No, I did not find any other case
Let me
like
repeat your answer for the record, because this is important. In all the studies that you did, you never found a unique case like this with the bed and breakfast. Is that correct?
Correct.
No further questions.
Thank you, Mr. Vaughn. Are there any more questions for the applicant at this time?
I've got a clarification about the lighting. You're stipulating there's not going to be any kind of assembly lighting. Does that mean there's not going to be any games in the dark? I mean, is that what this?
So I think that's a great question. I'll bring Ms. Makel back up to discuss their plans for athletics on the facility.
Yes, absolutely. Great question. So the way that our athletics work right now, we run athletics for 5th through 12th grades. High school, we don't always yield enough students to yield enough to make a team, so that is a lot more inconsistent. But the way it works right now is that our students have never played a home game. So we currently go off-site to do that. They have practices directly after school. School releases at 2:30. They typically have practice at 4 or until 4 o'clock. They're not always on our campus because we don't have the facilities, which is a part of the need here. Those practices are over at 4. When we have games, the games are over, depending on the sport, anytime between 4:45 and 5:30. So our flag football season tends to be the longest running game. Those games are completed at 5:30. They only run 2 days a week. Both of those days would not be home games for us, just the way that it works. And there are never athletic events on the weekends and never on Fridays.
Come on up.
But you can't predict what's in the future, can you?
I mean,
That's a yes or no question.
no.
No further questions.
And Mr. Mayor, if I may ask just to redirect.
Will you, for the?
Yes, Mr. Quick, for the applicant. Ms. Makel, if there is athletics going on in the future, could you hold events at night without lights?
No, we could not. We could not hold events at night without lights. So we plan accordingly that all of our events are completed before that.
Thank you.
Any further questions for the applicant?
I would like, what is the geography of the students? What's the range from where they come from? Well, it's a special needs, is that what words you used?
Yes, so we serve students in kindergarten through 12th grade with documented learning differences, primarily attention deficit disorders and language-based learning differences like dyslexia, sensory processing disorder, dysgraphia, things like that, of that nature. Our students this year come from 6 surrounding counties. So all the way Rockingham, Randolph, Guilford, Davidson, Alamance. In our past, we have had students come as far as Watauga County, driving down from the Wilkesboro area. So we typically serve the 6 surrounding counties, primarily Guilford and Forsyth.
And your operating hours are normally?
Yeah, so students can arrive on campus for early bird drop-off care at 7 a.m., and students leave campus for the day from their academic day between 2:30 and 2:45. Any athletic practices or things like that are until 4 o'clock.
One sec, Councilman Moore, did you finish your questions there?
I believe so.
Mr. Vaughn, if you want to come on up and cross-examine.
And you know where the bread and breakfast is located, don't you?
Yes.
And in your opinion, and you know your students very well, if the future happens like what you're predicting, would that be a problem for the bed and breakfast and sleeping and other arrangements there?
Objection calls for speculation.
Can you clarify your question, because I think I missed it. Can you ask your question again?
Do you think this would be a problem for the bed and breakfast?
The enrollment?
The expansion?
I do not, no.
Ms. Maker, will you come forward just to ensure that we can all hear you?
Explain your opinion why it would not.
Sure. So I don't foresee it being a problem, primarily because when we get into the second and third phases, currently our students, those are outdoor playground areas. So currently, throughout the day, they're in those spaces, being kids, running around, playing on the playground. However, when phases 2 and 3 are completed, those will become indoor facilities. So they will bring our students actually indoors into a gymnasium, or on that, where the modular units are that will be removed to make room for a playground, it'll move them over to that side. So it will be away from the bed and breakfast compared to where it currently is located.
Right across.
Yes, please.
So on this map, you know where the bed and breakfast is, and you know where your field is, and you're planning on putting a lot more students and others on that field, are you not?
During the day, no.
Are you doing them at night?
I mean, the only thing that would be in the evening or afternoon hours after that, on that athletic field, would be athletic games until the 5:30 that I was mentioning.
And how many more folk do you anticipate out there?
I mean,
You told me just recently you couldn't predict the future. Are you predicting the future?
I'm not predicting the future. I'm going based on the enrollment projected growth that we've put up there for our phases and conditions. So,
No further questions.
Any other questions for the applicant from council?
For Mr. McEldowney, if I may. Based on the drawings as they're presented here before us, in particular to the boundary line, and we've seen the pictures of currently that the field is all vegetation and wooded. As it is drawn currently, from the edge of the field to the end of the property line on the side where Seven Oaks resides, how many feet is that? My eyes aren't good enough.
Oh, let me use my finger as a scale. It's probably about 50 feet from the, I guess would be the northern corner, and a little bit longer.
Did you say 50?
50 feet from the playing surface to the buffer.
Okay, and from to the very inside of the property from where the goal is, you would estimate that would be how far?
It's probably close to 65, 70 feet because of the angle of the property line. I can get an exact distance for you if you need it.
Oh, I'm sure you can. I may have a quick question for the gentleman from Fourth M. If, again, and I'm not trying to, this may be a combination, but the process, it sounds to me, is the intention is not to totally deforest what's there, but only enough room to construct the field and any separation it might need. Is that correct?
That's correct. I mean, we want to provide a little bit of a viewing area around the field for people to set up a chair or whatever, but the intent here is to minimize cost and to minimize clearing, but, you know, without a design, a detailed design, we need to make sure we have flexibility so we don't have to come back and do the process again, so.
Okay, thank you.
Are you going to follow up on that question? Yeah, let's go ahead and get Mr. Vaughn up to go ahead and do his cross. Say it again? No, Councilman Andrew had a different question. So if you want to go ahead and cross based on what we just heard, you can go ahead and do that.
So, I know you're an expert in this field. From the edge of the field to the bed and breakfast is how far?
Well, without the,
Do the best you can.
well, from this corner, from the, I guess would be the south corner of the field, probably 80 feet, roughly.
80 feet.
Yeah.
And how far is this room to the other side, in your expert opinion?
It's probably 60 feet.
60 feet.
Yeah.
So do you believe that noise and other things could be heard by the bed and breakfast on a field there to the bed and breakfast? Do you think noise could be heard?
Objection.
No further questions.
We've not
No further
admitted
questions.
Mr. McElhaney as an expert on noise and sound. In fact, I will note for the record, Mr. Mayor, in the transcript, that Mr. Vaughn did object to Mr. McElhaney being admitted as an expert. The city and the applicant have agreed to that. I would consider him as an expert. Well, not on sound. Okay. Just to be. He was answering, my point here is he was answering questions as an engineer involved in the project, but not as an expert. We have not asked otherwise in given Mr. Vaughn's objection to qualify.
Objections have been noted, your objection a little while ago and your objection earlier, so thank you. And Councilman Andrew, why don't you go ahead and...
Yeah, one quick question. Have we heard from the residents of the 3 homes on Glen Clove Way and the 2 homes on, I'm going to mispronounce this, Garad Court, because they seem to be closest to the properties outside of the bed and breakfast, and have we heard from them, and do they have any objections?
Mr. Andrew, if you'll give me 1 second, I will point to where in the agenda packet, I understand your page numbers may be slightly different than what was online, so apologies for that. There was a sign-in sheet that was included in what we submitted as part of our citizens information meeting. And so I can represent here that there are, I see individuals who live at 2162 Glen Cove Way, 2182 Glen Cove Way, 2166 Glen Cove Way, were each present at the citizens information meeting. I can't say whether any of them necessarily spoke. I don't have that information in front of me. But then there were also, for Ember Oaks Avenue, individuals who live at 1308 Ember Oaks Avenue, 1314 Ember Oaks Avenue, another Ember Oaks Avenue without a, 1309 Ember Oaks Avenue. And so we've had individuals from that street, along with several individuals from Brandermere, all stub streets that approach the property, 3505 Brandermere.
Well, thank you. I saw the people who signed in, but what I'm looking for is there anyone else who had any issues?
There were several folks who spoke. I don't know if any of these were the ones who specifically spoke. So.
Okay.
Mr. Mayor, to follow up on, and maybe this is a question for Mr. Vaughn or his clients. You stated earlier that there were multiple individuals who had opposition. Do you have any sworn or written petitions or anything that may support?
We've got to save that for when it's time for their testimony.
Okay. All right.
Any other questions for the applicant? Okay. Hearing none, we'll do 2 things. One, there was a point made earlier in a question from Mayor Pro Tem about the zoning of the bed and breakfast as a residential. There is a question here regarding how that bed and breakfast could operate in a residential. Can you help explain that to us? Because it's a commercial business, but it is zoned residential. Can you explain that to us?
Once again, Herb Shannon. The zoning for the site is residential, single-family 3. The permitted principal use table would allow that use subject to obtaining a special use permit approval. That site obtained special use permit approval in 2011 to allow a bed and breakfast.
So the bed and breakfast itself obtained a special use permit?
Yes.
To become a bed and breakfast?
Yes.
Okay, understood. The other thing I know, sorry, did anyone have any questions for Mr. Shannon about that point there?
Mr. Mayor, may I ask a question?
Yes, please, go ahead. Well, yeah, but you gotta go back to the mic, so just, yeah, we've got folks listening in.
Mr. Shannon, were you the planner who presented that special use permit in 2011?
Yes.
Do you recall whether or not you had any recommendations with respect to the school when addressing that special use permit for the bed and breakfast?
No.
If I represented to you that you noted the school provided a buffer from surrounding residential property, would that be something you would find true?
It is true it's required per our development ordinance that at least a type B planning yard be required.
And with respect to the bed and breakfast being, the school being a buffer between the residential community and the bed and breakfast, would that be something you would find valuable or important?
Yes.
Okay, thank you. No further questions.
I have a follow-up question about
You
that.
go ahead.
If you go back to the first page of your slides,
The image?
the title page.
Oh, yep.
So if we're looking over here on the right-hand side, would we say that that buffer meets the requirements?
So, great question, and if you don't mind, I'm going to advance to all the way to the end of this and show you.
Well, I just want to point out why I'm asking, because right now, I guess this picture was taken in the fall, and so the foliage is not there. So you can very clearly see onto the other side of that tree line. And so I imagine the requirement doesn't say that you have to plant evergreen trees that would make it a buffer year-round. Is that correct?
So from answering this from a legal perspective, we would be required, if this doesn't meet a type B buffer yard under the city ordinances, we would then be required to go in and install trees to meet that requirement. So whether it meets it or not, I'm not qualified to say. If Mr. McEldaney is aware, I'm happy to invite him up, and he's not aware of that. But again, we would be required to meet that as part of our conditions.
Well, you just said that Mr. Shannon did say in that 2011 hearing that they were required to provide, that you were required, the school was required to provide a buffer that met the R3 zoning requirement.
What I was intending to ask Mr. Shannon was with respect to whether the school's presence between the residential community and the bed and breakfast itself provides a buffer, not a buffer yard. The use of the word buffer there was intended to be the property, not a type B yard.
Okay.
Sorry.
Councilwoman Cook, to get clarity, is your question about what is required in terms of the type of vegetation for type B? Is
It
that?
just spurred my curiosity because looking at this picture, I can clearly see through that. So I was asking if that meets the 20 to 25 feet requirement that we're discussing. I'm just trying to understand if they would have the ability, if they need to or want to, go that far in the development of the fields to have the same amount of buffer that's photographed here, that,
Yeah, so I think the question here, and perhaps staff can help us out, because what we're trying to get clarity on, our job here is to listen to the evidence by law of what's what. And so if by law, there's a certain type of vegetation that is required to be that type B landscape yard, we just need to get clarity that whatever we see here, is that consistent with what we think we're going to see there? And then if so, is that by law what is required? Or is something more required beyond that, such as not being able to see through there?
Make sure I understand your question. Based upon this photo, you want a determination, does that area along the northern portion of this photograph meet the type B planting yard requirements?
Yes.
I do not know the answer to that question. What I can state that if this is approved, the applicant would have to have a landscape architect submit a landscape plan and document either the existing vegetation meets it, or they would have to submit a landscape plan and install vegetation to meet that requirement.
So basically what you're saying is, regardless of what's there now, we can ensure that in order for them to move forward, they would have to have the legal standard there in order for them to make that happen?
Correct.
Okay.
And just for clarification, with that type B planting yard, doesn't mean you're not going to see through it. It's not to the point where you're not going to see anything past it, but it is a visual filter between uses.
Thank you. Councilwoman Cook, does that
I guess my
clarify?
question is like, if there's not a requirement for the type of tree that goes there, then the amount of impairment that it provides would be seasonal.
Understood. Yeah. Understood. And that's noted. I don't know if there's anyone here able to speak to the type of vegetation. I don't see any landscape architects here. Do you want to speak?
Mr. Mayor, if I may, I guess this is technically a redirect of the city's witness. Mr. Shannon, can you please tell the council what is the type B semi-opaque landscape yard requirements as it relates to the type of trees and shrubs that are required in the ordinance?
Per the development ordinance, a type B planting yard would require 4 canopy trees every 100 linear feet, 6 understory trees every 100 linear feet, and 25 shrubs every 100 linear feet.
And am I correct in restating your testimony that you cannot tell from this picture whether or not that meets that, but that they are required after, if this special use permit is approved, to submit a plan that shows that that requirement is going to be met?
Yes.
Question, why is that not required prior? I mean, it seems if the special use permit is granted, then they have to go back and see if they meet compliance. Why is that not required prior to submittal of the application, or along with the submittal of the application? Because if they don't know if they are currently in compliance with the current foliage, why would we not require that information up front?
I'm not sure I understand your question. You mean?
No, I'm saying, the question I'm asking is that we approve the permit, they then go do an analysis of whether or not the current vegetation meets the requirement. Why did we not ask them to do that analysis up front to see what any potential future vegetation would need to be planted there? Why would that not be required up front?
The staff does not typically say, prove that you're meeting the requirement. We would tell them, here's the requirement, or here's the condition that we recommend. If you get approved as part of your plan approval, you have to show that and document through your landscape architect that either the existing vegetation meets that requirement or that you're going to install it. We do not require them to approve that up front.
Can I get clarity here? Sure, certainly. Because part of this is that we're approving a process that starts, and then there's a series of other permits that they get for construction and demolition and clearing and all those things. And before they can move forward to get some of those other permits that would be approved by our technical staff, they would then have to have that architect, the landscape architect, show all of that the way it needs to be shown. Is that correct?
Yes.
Same way, we're approving the permit tonight, but that doesn't mean that we're saying they can have 200 students. We're saying that we're approving the permit, and should they trigger what needs for the students, there is a process to go through for TIA, the Technical Review Committee, and then all the turn lanes and all the things. And if they can't meet it, they don't go to 200 students. So it's kind of like we approve it tonight, and if they, for some reason, can't afford to do that landscape, they don't get the rest of those permits or whatever that needs to happen. They just simply can't move forward from a technical standpoint. Am I understanding that?
Yes. If you would be approving the use, they would still have to go through the appropriate review process and document that they're meeting not only the requirements of the development ordinance, but any conditions that are adopted.
Thank you for the clarification. Mayor Pro Tem, does that help get clarity?
It clears it up. I don't know if I'm necessarily satisfied with the sequencing, but I understand the process.
Commissioner Cross?
Yes, sir.
You just described for us a type B planting yard, is that correct?
Yes.
Is that going to provide a noise buffer for these neighbors as illustrated in their picture?
I'm going to read from the development ordinance. Type B semi-opaque landscape yard. Intent. This landscaping yard functions as a partial opaque screen from the ground to the height of 6 feet. This type of buffer prevents visual contact between uses and creates a sense of separation. That's the intent of the type B planting yard.
So it's not intent to knock out noise, is that correct?
That is not in the definition.
It's not intent to knock out visual problems between a field and a bed and breakfast, is that correct?
Objection.
That's specific.
Objection noted.
Next.
Thank you.
Said what the visual buffer is. So he answered that one already.
Mr. Vaughn, do you have any questions for anything he's not answered yet?
Do you think that's sufficient protection for a neighbor?
I'm going to object to that speculation.
Objection noted.
I don't believe that's speculation. I think it's an excellent question for this body. Isn't this a unique situation with the bed and breakfast?
Objection.
Object.
This is speculation.
Mr. Shannon is
Yeah.
not needing to speculate as whether something's unique or whether there's certain impacts. It's not his job.
We'll just withdraw the question.
Understood. By the way, Mr. Vaughn, when you all get to your testimony, we'll look forward to some of these things being mentioned. Y'all, we're going to pause here for a second. I'm going to go ahead and submit a motion or put forward a motion that we recess for 10 minutes and everyone come back at 8:05. Is there a second on that?
Second.
Second made by Mayor Pro Tem Holmes. Any discussion on the motion to recess? All those in favor, please signify by saying aye. Any against? The ayes have it, and we will recess for 10 minutes. We are coming back from our recess. This is the regular meeting of the High Point City Council. We are in the middle of our general agenda item 2024-407, quasi-judicial evidentiary hearing for the Piedmont School Incorporated Special Use Permit 24-01. We have just completed hearing applicant testimony, and before we transition to hearing from other party testimony,
Confirm that.
I will confirm that we are done with our presentation unless council has any additional questions for the applicant.
no, we're good. We've just finished hearing from applicant testimony. Before we hear from next party's testimony, we will disclose an email received, the date uncertain at this point, but we can certainly put it in for the record, from, I believe it was a parent of the Piedmont School, David Black, who emailed us about the case, and our response was to put him in touch with the attorney and to be clear that we couldn't talk about it. So there was no actual back and forth with David Black about the case, but just want to make sure that that's disclosed for the record.
Mayor, that was sent to you and Mayor Pro Tem
Yes,
Holmes. Is
yes.
that-
Yes, sorry, apologies. That was sent to myself and Mayor Pro Tem Holmes. All right. The other parties in this case may now present evidence and legal arguments. As a reminder, any evidence and argument must focus on the applicable standards. Documents and other physical evidence referred to or used by witnesses will need to be entered into the record, and a copy left with the council for that purpose. Before you begin, please state your name for the record, address in relation to the case, and please confirm for the record that you were sworn in. So we'll get your name, address, relation to the case, and affirmation that you were sworn in. If you forget, I'll remind you.
Thank you. My name is Ron Barker. Address is 833 Old Mill Road, location of Seven Oaks Bed and Breakfast. Now, yes, I am sworn in.
Awesome, thank you. Please begin.
As has been presented by council, or the proposal, I am very pleased with council's questions, and going back to my encore notation that I did earlier in the event, 815, yeah, you got the double multiple going there. Current zoning for 815 Old Mill Road is R3, designated as low-density residential. While R3 does allow for limited commercial entities, any request must be made before City Council. Seven Oaks completed that request in 2011 and subsequently was granted a limited use permit, specifically limited use. When Seven Oaks later returned to planning and zoning to request an amendment for limited events under 50 guests, we didn't get past planning and zoning. We were completely told flatly no, that there would be no disturbance. This would definitely citing disturbance to the community. So we were denied any application for events at Seven Oaks. Now the Piedmont School comes before the council with the largest expansion to date within the Old Mill community, a much larger facility than this neighborhood has experienced to date. I wish to point out that, as far as I know, and would like to clarify, the Technical Review Committee is planning and zoning brought before City Council. The subject of the buffer, the Type B planting yard buffer, and Mrs. Cook very wisely pointed out the foliage between Seven Oaks and the school is annual foliage. It is not evergreen. It is not pine. It is not Leland. It is not evergreen in any way. And when the season ends, those leaves are currently on the ground. And she pointed out there is a clear view of the lighting. The current existing building lighting shines directly onto Seven Oaks building. We have plantation blinds on each window to block that lighting from the bedrooms of Seven Oaks. There is not even the remote. I have lived on this property and cleaned this property since May of 1996, many years prior to the Set Bed and Breakfast. There is a shared boundary between those two properties, Seven Oaks and Piedmont School, where some of this foliage currently exists, which is now not a filter in any way. As Mr. Shannon did explain very well, Type B planting yard is a filter. It is not a block. It is a filter up to, I believe, clarify me, up to 6 feet. With this athletic field proposal, even though they're proposing that there would be no athletic field lighting, it was discussed at the community meeting at the school that there could be nighttime safety lighting up to 10 feet surrounding this field, if I'm correct, if someone wishes to clarify that. There needs to be a review, and it needs to be brought to the attention of technical review to come out there and complete the process. In this case, because all cases are unique, that the property needs to be viewed, and as Mr. Holmes brought to your attention, needs to be implemented and done before construction. The prevailing winds in this area, and I have lived there for 25 years, are from the southwest. When grading begins, dust, noise, all forms are going to blow over onto the facilities of Seven Oaks. We currently, every spring, we pressure wash the house to keep it clean for our bed and breakfast. We have a pergola on the property for guests leisurely to relax it. We have a fire pit. All of this is subject to the fallout of any proposed construction. While the Piedmont School is presenting a plan that they feel is adequate, here again, this is an untried proposal with no proof that the proposed Type B planting yard will provide enough protection for surrounding property owners. I will simply just touch base again. These are just a few examples of events that warrant additional infrastructure planning on the part of the Piedmont School. At the minimum, an opaque barrier high enough to block both sound and light continuous on the entire length of the east boundary of the Piedmont School, along with natural sound absorbing landscape, should be required by council before considering the Piedmont proposal. We have hundreds of reviews on online travel agencies, Google, that I would hope many of you have had the opportunity to go and review, that guests frequently discuss or comment the peace and serenity that Seven Oaks has offered for the past 13 years. It is really up to the community and the people who live in that community and work in this community to create harmony so that both can coexist. It is with that, I implore council to delay any consideration until they've had a more thorough technical review, which includes, and I welcome all of you to come out and walk this property. I walk it every week, every day. And I think in order to consider the continuity of the community, it would be very wise that you folks come out and view this property at any time, weekends, weekdays. I would like to now bring up Ms. Barker, Dorothy. I'm sorry, do you folks have any questions? I'd like to answer any questions I can.
Well, before we get to questions, Ms. Barker, are you going to offer a testimony as well? How about we let you all get through your testimony, then council will ask questions of the entire sort of party at that time.
Sorry, I'm a little short. You can move it down? Awesome. I want one of these at home. So my name is Dorothy Barker, and I go by Jenny. And I live at 833 Old Mill Road, and I have been sworn in. I want to say I'm a little bit at a disadvantage here. when all of the meetings and everything were being held that talked about this, I was visiting my son in Hawaii and for 2.5 weeks. So I missed all the meetings that were held. So there may be things that I'm not familiar with that I have concerns about. So forgive me if I mention something that's already been discussed. And I also wanted to mention that the neighbor at 4013 Gerard Court was going to be here tonight, but his mother is in ill health, and it was his turn to sit with her. So there are other neighbors that are concerned, but they did have other family obligations that they could not get out of tonight. So one of the things that I want to bring up is not only do we own the property at 833 Old Mill Road, we also own the property at 839 Old Mill Road and 4007 Gerard Court. If Mr. Shannon would I don't have copies of the maps and everything that were put up. I was not privileged to those, but if Mr. Shannon would mind putting up the GIS map so that we can get an idea where our property is located in reference to current location of the school.
From the PowerPoint. You're talking about the PowerPoint?
The GIS map.
That had the aerial?
The tax map that shows our
Okay.
property in relation to their
So bring
property.
up the point.
No, we can't do that.
Okay.
It's not part of the record. You need to go to the actual GIS map in your PowerPoint. Can you pull up your PowerPoint?
And I think it'll answer some questions if I'm able to give you a visual. I'm a visual, so it will help me. Thank you for your patience.
Yes.
Okay, can we zoom in?
There you go.
Okay. What you see is the green or blue outline, that's the school's property. If you look immediately to the right, there's that
Can you give
cutout.
her access to the pointer, please?
Want the red dot?
No, that's fine.
Okay. Okay. So this long stretch right here is 833 property. This small area right here is 839 Old Mill. That's the house that Ron originally lived in when he purchased the property. And then there's a stretch here that is 4007 Gerard Court. So we own 4.92 acres right there that, as Mr. Barker said, is about 40% of the property on the east side of the school line. One of the reasons I wanted to bring this up is, first of all, this area right here that I'm pointing at is the playground for the school. There have been times where I have been out working and just one classroom is on the playground. And I can be standing over here at 839 Old Mill Road and still hear the kids screaming. And I don't mean talking loud, I mean screaming. There was one student several years ago that I think he only knew the top of his lungs when he was out there playing. It's very distracting, it's very disturbing. I kept wanting to go over to the school and say, is this child okay? I mean, he's just screaming. So even now, I get noise residual. We get noise residual from the school. That's just one classroom. So think about the athletic field. You see, this is our main house right here. This is where the bed and breakfast is. That athletic field is going to go right here. If I can be greatly disturbed by one classroom of students out there, and it's up here, what do you think our guests are going to experience with an athletic field being right outside their window? The other problem we have is the school refuses to lock their front gates. We have called the school and said, you had somebody trespassing over the weekend. They were on your property and playing loud music and playing on your basketball court. They said, oh, well, we don't lock the gates because if we do, they're going to cause more damage than if we lock them. So what happens is at night and on weekends, we have to deal with their problems. Several weeks ago, there was someone sitting here in their parking lot playing the bass on their car stereo, and it reverberated into our bedroom. And we had to call the police to get the police out there. So not only did it disturb our sleep, we had to get up and go meet with the police to find out where it was coming from and to meet them to tell them where it was at. I got in my car and I was trying to locate the noise. And I pulled into the drive for the school and the car was coming out. I turned around because I was just at the entrance of the school and I went back to my drive. The car pulled out behind me, and when I pulled into my drive, he stopped on Old Mill Road right behind me in a threatening gesture. This is what we put up with now. So just think, you're going to have an athletic field in your backyard. So the bed and breakfast is kind of unique. I don't know how many of you have stayed at a bed and breakfast. It's unique in that it's more of a family, peaceful, relaxing, small environment that people come to for that more homey feel for rest and relaxation. We have around 100 reviews that I gave Mr. Vaughn. I didn't look at every one of them, but the ones that I read, almost every one of them discussed how quaint Seven Oaks Bed and Breakfast was, how much they enjoyed their stay, how quiet and peaceful it was, how they enjoyed nature and deer and foxes and that cup of coffee on the front porch after their breakfast. When you have an athletic field in your backyard, that's not going to happen. The athletic field will be directly across from our Master Oaks bedroom window and our large master bedroom bathroom that people come to enjoy the large hot tub that we have in there. So when they're trying to relax in the tub or in their bedroom, and same thing with upstairs, we have another bedroom upstairs that has a window that also will face where the athletic field is going. So not only will they hear the noise when they're trying to rest, yes, we will get bad reviews. And yes, people will stop coming. The other thing is that we have all kinds of guests. people coming in for furniture market. Right now, we have guests there for the fabric market. We have people who do staycations, honeymooners, people who are getting ready to have children and they come before the baby is born. We also have people who come and stay, and while they're there, they work. They hold meetings in their rooms. They go on the front porch and they have meetings. If you have an athletic field next to those rooms and next to that porch, they will hear that noise. They won't be able to sleep. We have people who sleep in too. Ron fixes breakfast for them, but there are times where they don't come out for breakfast. No matter how good that breakfast is, they just sleep in. They want their privacy, they want their quiet. You're not going to get that when there's an athletic field right next to where you're sleeping. The trees are not going to be enough of a buffer. If we can already hear the noise from one class on the playground up here, and I'm all the way over here, what is it going to be like when right here out your window, there's a whole group of people yelling and cheering and making loud noises? And I don't know if you've been to games, but parents, they bring noisemakers. Who's to say they're not going to have loudspeakers and bullhorns and all kinds of things? And our guests are going to be subject to it. That's just with the athletic field. What I don't know also is how long they anticipate these phases lasting. I have no idea. But I can tell you right now, I know enough that the dust, the equipment, the noise from the hammers, all of that is going to permeate over to our property. And it is going to interfere with the resting peacefulness of our property. This gentleman said that it is not going to interfere. I would say that everything that has been said here tonight is an assumption. I've been in the Marine Corps, sorry. Assumption is not a good word in the Marine Corps. Mr. Andrews knows what that means, and I'll tell you what that means. When you assume, you make an ass out of you and me.
Ms. Barker,
Yes, sir.
can we keep it straight? This is an evidentiary hearing.
My
We wanna hear
apologies.
evidence.
My apologies. I was clarifying the why the assumptions are not proper.
Understood. Thank you.
So this hearing is not about presuming things. They can't tell us about lighting. They can't tell us about noise. They can't tell us about how all of this will impact Seven Oaks Bed and Breakfast because, frankly, no one's been out there to ask us. No one's been out there to be a good neighbor and say, hey, how can we work with you to where you can still have a sustainable business and enjoy your property while we grow our school? No one has. So I think that the big problem we have here is they don't understand how it's going to impact us. It's basically going to ruin our business. Because I guarantee you, all we need is one bad review that someone's going to go there and say, God, it was so noisy. They're building a school over there and all that noise, or they're going to get done and the athletic field is going to be right there. And all it takes is one review saying, oh my gosh, they were holding some kind of a tournament or something over there and it was so loud. We didn't get to rest. We couldn't even sit out on the front porch. It was so noisy. So if you think that this is not going to affect us, I think you need to come back and really do some soul searching and really need to see it from the other side of the coin. Maybe, just maybe, we could work something out to where both of us,
You have to testify here.
sorry, maybe we could work something out to where both of us are happy, but that hasn't occurred. We have tolerated a lot of things from the school. We have tried to help the school out. For example, like I said, when somebody trespasses on the property, we try to let the school know. We try to make sure the school is not being vandalized. When one of their students came over onto our property because there's some stray cats and they feed the stray cats even though we're trying to get rid of them, that student was trying to get one of those cats. And he came on our property chasing after that cat. And the school didn't even know it. We called him up and we said, hey, one of your students is over here. She says, yeah, we saw him on the video and we told him that's not proper and not to do it again. These are some of the problems that we're having. This is why we have a concern. Thank you.
Thank you. Does council have any questions for the witness?
I have a few questions.
Councilwoman Cook.
I wanted to know if you had copies of the police reports or the times that you've reported these incidents.
I've not run them, I have not run them off. The city has a new reporting thing where you can go online and report it. And I do have it in my email, but honestly, I am a student right now, and I am greatly inundated with classes, and the fact that I could even be here tonight was a challenge, so.
Chime in. These reports can be readily available. We just need to go back to the police department.
I'm just curious, if you had these claims, I think it would have been helpful for you to come in with them tonight. I don't know that it will do
Understood.
us any good after the
I
fact.
can look it up on my phone if you need me to.
I don't know
But
that that
to
would be
your point, you're-
permissible at this
yes.
point,
Yeah.
but,
They're not
okay,
here, but
I
they are
just wanted to
available.
clarify if we had any evidence
But
of
this is-
the number of reports
Yeah.
or what the police findings were in any of these cases, because,
He had taken a picture of the car,
yeah,
but
I understand.
We-
I
yeah.
just- I
Um,
wanted to know if we had anything
The
here.
frequency of the events.
yeah, it varies.
Thank you.
The incidences have occurred over a period of time. It's not something that just started. It's something that has occurred. I moved over to the property in 2006, so it's occurred off and on since I've been on the property, so I don't know what happened before.
It's over a 10-year period.
Okay. And then when you got your R3 limited use permit, were you required to plant a buffer zone to prevent the school from any noise or visuals on your property? Is that required in the limited use permit?
May I answer that?
Go ahead.
Based on the limited use, special use permit, the maximum number of guests at any time is 8. And as I cited earlier, we're not allowed to have any outdoor events. And so it was determined by the committee at that time, the council, that we would not be required to have a buffer.
Is there any reason why you haven't chosen to plant it based on the,
We have trees.
There are trees, and they are annual foliage. However, as Ms. Barker, my wife, Jenny, has clarified, the guests are there, they're quiet. We are also a autistic certified community, and we have a number of autistic guests in those areas out there by the pergola. The fire pit are what we designate as quiet areas for families to go with members of their family for serenity, if that's correct. So no, it was never even brought up by Mr. Shannon's group when it was brought forth that we would be requested to put in a buffer.
But we do have, I'm a tree hugger, so I do not cut down trees unless there is a absolute positive need. The only time that I cut any trees that are around the yard is if I need to cut them higher to where I can mow. But the buffer that's there is the buffer that has always been there. And again, it's, gosh, man, how wide is that?
Well, there is a plant there, but I mean, let me clarify. There is no outdoor lighting other than the floodlights on the east and west side of the house that would be aimed or even residual affecting the school's property. Currently, the school's lighting with its residual radius does project over to and onto the house.
With its current lighting.
Yes, sir.
Yeah, we do, before the leaves fell, we can stand at the house and see the lights that are on the front of Piedmont School.
Front and
in their,
side,
in their,
actually.
yeah, in their parking lot and all areas, so we can already see that.
I guess I was just curious, if it was such a problem, what actions you've taken to mitigate it from your side?
Well, and I will say too, is right now, their playground is down here, right down here. So, and their athletic field is up here. So it's far enough away right now to where if I'm up here working, I hear it, and it's excessive, but back here, it's not as excessive. In other words, the guests can still go out on the front porch and enjoy the front porch and still have some quiet. So that's really the difference, is up here with the playground here, if I'm up in this area, it's loud. But when I go back down here, it's not that noticeable.
Mr. and Mrs. Barker, I just want to ask a quick question. For the claims you're making, do you have any evidence?
What do you mean claims we're making? Do we have any evidence? Can you clarify?
For example, the light shining on your house, the noise you hear from kids. Do you have evidence?
Oh, you mean
I have
photographic evidence?
I have a video on my
Do you
phone.
have evidence right now that can be submitted for the record?
I have a video on my phone that I'd be glad to send over to him, and I have the police report that I would be glad to send over to him.
No, So I just, because I know, we don't do a lot of these SUP, quasi-judicial evidentiary hearings, but we've got a great city attorney who spent months preparing us for it. The very clear thing, just to make sure everyone's clear, because I know I said it before, any evidence and argument must focus on the applicable standards.
So you
And
need
it's got to
photographs
be,
to show.
and you got to have evidence for it.
I have one that I can give to Mr. Shannon. I have a police report and a video that I took that shows the lights, that we
So-
can already see them. And I did want to add also, if I might, there are concerns with traffic on Old Mill Road that were not addressed. The school, and again, I apologize. I have 5 classes that I'm taking, and to keep my head above water and trying to do everything I need has been, challenging. So I had not come, I didn't know what to expect. I didn't really know that I was going to be talking tonight. So I did not prepare anything. If I had known, I would have prepared more, but I did not know what procedures were. So I apologize for that.
But to answer your question, yes, she does have that, and we can either email or put that to him as we
So
speak.
what I'd say is, and to be very clear, I'm the furthest thing probably from a judge in reality, but I do get asked to kind of, while I'm sitting here, to think about it. If this was a court of law, Mr. Vaughn, I mean, there's claims being made, and we don't have any evidence to look at. And
Well,
we're being asked,
I don't want to be disrespectful, but I think that some of the things that the school is presenting tonight, they have no evidence on either. For example, how this affects us. And so I think that the council has been kind enough to hear their evidence without them having presenting proper evidence tonight. So the fact that we don't exactly have everything either, but we live there. None of these people live there. We live there. We put up with it every day. We know what's going on. The other thing I was going to add out there is the entry to the school is at the top of a hill and on a curve. As you can see right here, there is problems with traffic. When you come around that curve, you can't see a car stopped around that curve. So if there's a car that can't get into the school because of traffic, you got to slam on your brakes to keep from hitting that car.
Do you have a petition from your neighbors saying that this is a traffic issue?
No, but also the school does not have any kind of Department of Transportation information stating that it is a traffic problem. We've been told that the school doesn't even have to present that, just like the school doesn't have to present how will it affect people with wells in the area, because there are still people with wells. And we're on a watershed. We've been told we can't do anything with our property because we're on a watershed. But the school is being told it's no problem that you're on a watershed. You can do what you want.
Mr. Shannon, can you step forward, please? I'm just very curious, because she did actually get to one of the applicable standards here. Did staff's review of this, what did you ascertain in terms of the impact to our watershed there and potential water quality? I think I heard something about stormwater improvements with the potential construction, but can you speak to that?
What we noted in the staff report is this is in the Ocala Lake watershed critical area, tiers 2 and 3, and there's limitations on the amount of impervious coverage. The site can be developed, but they would have to meet that impervious coverage limit, and that any new impervious coverage would have to be treated by a stormwater control device.
And are they treating anything with a stormwater control device? I think what council's trying to hear, she just made a claim that they're going to impact public health here with water, and we're trying to be very clear.
If this is approved, they would have to go through our technical review committee and submit engineering plans that document this is how much additional impervious coverage is being added, and this is how it's treated. The plan that was noted in the exhibit does note an area where they're proposing on-site stormwater control.
Okay, understood. And did the council have any follow-up questions specifically for her claim about water? Okay.
I'll also add that, according to Mr. Shannon, we've been told one thing. We've been told we can't have events because it bothers the neighbors. We've been told you can't have a little pond on your property because you're on the watershed. We've been told that we know that there is an ordinance that talks about trees and what trees you can cut down and what trees you need to save and things like that. There are things that we're aware of and that we've been told that we can't do, yet the school has been given carte blanche to do whatever they want to do without paying attention to any of these other issues that we've been told we can't do.
Ms. Barker, we can't actually adjudicate
I understand
a
that.
past case of that. So to be very clear, I'm gonna just read for you. Give me 1 sec. So as provided in section 2.4.12.c of the development ordinance, special use must be approved upon a finding that the applicant demonstrates the proposed special use. And this is them ensuring that, one, it will not materially endanger the public health or safety if located where proposed, complies with all required standards, conditions, and specifications of the development ordinance, will not substantially injure the value of the abutting land, will be in harmony with the area in which it is to be located, and is in general conformity with the city's adopted policy guidance. So what our ears are filtering for is, are you making arguments and giving us evidence that tell us they won't do something there? If it's anything else, all due respect, by law, we cannot side with you unless you're doing those things.
Understood.
By law,
I would also,
to be,
apologies.
because council gets a lot of things we hear. As she mentioned, there's legislative things we get. And those legislative things, we get to decide which way we go. We get to hear people's opinions. And based on kind of the sway of political opinion at the time, sometimes we make decisions that maybe you could say either or it goes a certain way. On cases like this one, it is a legal, quasi-judicial, evidentiary hearing. So it really doesn't matter. I could love you and want your property to be the very best bread and breakfast in the entire country, and know a school is going to hurt it. But if the evidence that you're presenting tonight doesn't say that, if the evidence that you're presenting does not say that, then by law, we cannot just simply say we like you, and so we're going to help you out here. We have to go with what's evidentiary.
And I will close with the fact that I don't feel like that they have done their due diligence in determining how this expansion of the school will really affect the area surrounding their proposals. And I think that if City Council makes a clear point that we don't have the evidence to substantiate our claims, they don't have the evidence to substantiate their claims either. Because there's part of their evidence that they are coming in here and presuming it's not going to affect Seven Oaks Bed and Breakfast, presuming that the buffer that they are projecting will just take care of our business and won't harm it at all. I'm finishing.
Yeah.
Right, I'm finishing.
Mr. Vaughn needs to make.
And what I'm saying, though, is that I understand what you're saying in that we don't have the evidence tonight, but I'm asking City Council to take into consideration they don't either.
Okay.
Thank you.
Before you step away, just want to make sure, any questions for the witness from council?
Yes, Mr. Mayor. Mr. and Mr. Barker, I understand you ascertained the singular impact to you, and we're asking for evidence of that. I know on the other side, Montclair, Ember Oaks, Saddlewood, there is also development in homes.
Yes.
Those are your neighbors. This has been going on for some time. Have you or have any of your other neighbors spoken to you in some type of sworn manner, written manner, that says that they share your concerns about the future development?
Mr. Barker has talked to some. I have not had the privilege of doing so.
Because I see that on your side of it, your property takes up pretty much the majority of the connection to the future site, but there are some homes on the other side. And I'm wondering, either have any of them joined you or been willing to?
As Mr. Vaughn did ask for a continuance, and as I stated initially when I came up, there were a number of individuals that wanted to be here, but because of family obligations that conflicted, they were not able to come.
Yeah, and I can completely understand that, but I think given the time frame that this has been going on, there should have been at least some consensus from your neighbors in opposition with you.
There was supposed to be another lady here tonight. I don't know what happened, and honestly, Councilman Holmes, I can't speak to them.
Sure.
I can only speak for myself. I know that we have contacted the neighbors. Mr. Barker has talked with them about their concerns. He has stressed to them that the importance of them being here, and I can't speak to that. All I can speak to is me and Mr. Barker being here. So they have expressed concerns to us.
Ms. Barker, respectfully, I think in terms of council coming to a decision whether or not this is going to cause a disparate impact, we just can't consider Seven Oaks. I mean, there are other folks there. And
Even though it's going to kill our business.
I mean, I can't say that that's going to happen, ma'am. I can't predict that. But we're talking about establishing whether or not that there's going to be disparate impact to the entire area. And if there's no one else here, or if you don't have evidence that other folks are going to be impacted as seriously as you are, I mean, it's very difficult for us to make a singular.
And that's why Mr. Vaughn asked for a continuance, because he knew that these individuals were not able to be here. it's been going on, but there were other individuals that were coming in October, but matter of fact, there was one lady that sat here for most of the evening, and so there were people coming then. So I think that to penalize Seven Oaks Bed and Breakfast because someone else had other obligations and cannot be here, it does not mean that it's too many knots. It does not mean that they are not concerned. It does not mean that they do not have concerns. This is only the second meeting. The first meeting, they came to the school, and he has, 28 names or something. They came to the school, and that is the only these 3 meetings are the only ones I know of. So it doesn't really give people who have other obligations the opportunity to come in and voice their concerns, and that's why we asked for a continuance.
Madam Attorney, can you speak to the item of continuance here?
So I have received no request for a continuance. Mr. Vaughn and I spoke as a courtesy over the weekend, asking if he would be representing his clients. He said that he would be here and that he would have no objection to a continuance, but I said nobody had requested a continuance. So to be clear for the record, I'm not sure exactly what the request for the continuance is. I don't know if any other party has heard anything about it, but I just wanted to be very clear that we have
There
not
was no
received a
request
request
for continuance. Okay.
But, may I?
Yep, Councilmember Moore.
But even the ask of a continuance is not going to change what's being asked of this council, because we're looking at a judicial request here for a SUP, and it has to be based upon the 5 parameters that you laid out. Is that correct?
That's right. Those standards will not change. Those are the legal standards with which the council will make a decision.
And I just want to say that Councilman Holmes is concerned about no other voices being here. And so that's the conversation that we had. I understand what you're saying. It doesn't change the outcome, but his concern is he feels like, what I'm getting from his comments is that we're the only ones that are concerned. No, that's not accurate. We're not the only ones that are concerned. It's just unfortunate that the other ones had other obligations that couldn't be here. So a little bit of a difference there.
Are there any other questions from council for the witness?
Just maybe one more comment, and Madam Attorney or staff, tell me if I'm wrong. Based upon a decision tonight, even if approved, this site is not set in stone, and the buffers and parameters are not set in stone. And even the applicant has stated that some things may change in layout or other circumstances, as is not uncommon in the development process. So we're only working to get to the first step in the process to move forward on the final approval of their plan. Is that correct?
Yes, and to qualify that, so the request has for special use, so this is all about the use of the land, which runs with the land. There are conditions that have been negotiated between the applicant and staff, so those conditions will not change. But any of the technical matters beyond that still have to go through the Technical Review Committee, which is a committee of staff that is different than the Planning and Zone Commission. That has nothing to do with this matter.
Correct.
The Planning and Zoning Commission does not hear special use permits.
Correct.
So there's still a number of technical review and logistics and details. The only thing that is set in stone is the type of use and the conditions as presented in the staff report.
So the actual layout and process of what this could or could not look like, based on the concerns the Barkers have raised, still has time in process to be negotiated. She referred to the fact that they had not heard from the applicant, this and that. I'm not here to just get into that discussion, my point is, in the process of the time frame, that communication could still have the opportunity for them to engage in those conversations to hopefully reach, as she referred to, a more mutual agreement as to what it could be. Is that correct?
That's correct. Not to speak on behalf of the applicant, but what everybody saw tonight in testimony was illustrative purposes only, for informational purpose only. There is no binding site plan. The only things that are binding are those conditions that have been negotiated between the applicant and the staff.
So to follow up with Councilman Moore's point, hypothetically, there could be a discovery where the applicant finds insufficient buffer and has to meet that buffer, which may be sufficient for the Barkers to be satisfied with what that looks like, post-approval.
Go ahead.
If you want to come on up, because you asked a question about applicant, if you'll come on up.
Well, I wanted to clarify for the record, the phasing plan and the queuing exhibit are explicitly attached as exhibits to the conditions, and so we would be required to comply with those.
Right, I'm sorry, to clarify, those were, but like the site plan is not a binding site plan. That's information purposes only. The plan that was up there, not the phasing plan, but the one that said informational purposes only.
Correct, yes.
And I just wanted to ask for clarification that there was nothing in the conditions about the operating times on the property if the school in the future does have events that go later or expands into larger events on that land. Even though right now they're done at 5:30, there's nothing in the documents that would say that that's how it will always be.
So I would let staff address that.
Yes, and Councilmember, the important thing to note is that just like with your rezoning conditions, the special use permit, these are draft conditions that have been negotiated between us, staff, and the applicant. But if there are conditions that you want, all reasonable conditions on a special use permit are allowed to be added. So it's not set in stone that way. If the council, wishes to have a reasonable condition added, it is allowed.
A point of clarification on Councilwoman Cook's point. I think I heard Ms. Mako mention in terms of when those activities take place, they stop at 5:30 because you can't go beyond 5:30 into the evening time when it's dark unless you've got, there's certain lights required. We worked in education. Athletics requires, you got to have certain lights if you're going to play at night on the field. And right now, the lights that are required for school athletics to be played at night, those lights are the ones that I think we are not allowing at this point. Is that correct? Staff, with the high mast lights?
Correct. If that is off a condition that there be no athletic lights, they have a condition that lighting not exceed 35 feet.
Yeah, so there's a whole condition around athletics. They don't just let kids go out there and play with street lights. You got to have real lights out there because someone could get hurt. And they're not going to allow anyone to go out there to play. This isn't them. This is commissions at the state level. They're not going to allow folks to go out there and play at night.
I guess what I was
without real
asking is,
lights.
there's nothing preventing them from putting those lights in later, applying for that use.
They have to apply for a new special use permit. They have to do all this
There's
again.
nothing in here that says that they can't do that if
No.
they get to
Yeah,
the point where
yeah.
they want or need to.
Yeah.
Is there anything that prevents them from renting their space out for other events to be held?
Like if someone else wanted to have a party on the field at night.
Or if they, Saturday morning soccer matches, tournaments hosted there during weekend hours when they're
Great
not?
question. Is that condition being met, staff?
There's no such condition that states that. And with all conditions, you have to make sure something that is enforceable.
That's a good point.
And if I might add, our normal check-out time is 11 o'clock, and check-in is earliest is 3. However, we have guests that stay for multiple days. They do work there. We also have guests who like to come in early. So we have had guests that's come in at 12, and if the athletic field is put next to the bed and breakfast, it's not, there is an issue of lights, and I do know that the school has discussed a football team. There is a chance, because soccer fields are always looked for, there is a chance of weekend activities, and also the noise, even if they have the games until 5 o'clock, we have guests that check in as early as 12 o'clock. So they would still be able to hear the noise and be distracted and disturbed by the noise that would be going on in the athletic field.
Yeah, no, I'll ask a sort of clarifying piece here. I think, Councilwoman Cook, you raised a great point that actually is one I think we have probably hadn't heard yet tonight. But I think of the 5 pieces here, what that would kind of get into would probably be number 3, substantially injure the value of the abutting land. Right now, we've still not gotten any evidence that says Saturday morning soccer games will injure the value of your land. I'm just stating for the record, we've not gotten any evidence that says that.
Would you like us to put into evidence all the referrals, or not referrals, all the reviews that we have gotten?
So that actually gets to a question I had about reviews, because you mentioned that they're quaint and quiet. Those were the reviews, 100 plus. Did you have any reviews where people talked about the screaming kids?
No.
Did you have any reviews that talked about the needles,
They talk about the what?
the drug needles that you referenced?
They did not find that. That was something that we found before the guests
Did you
had
have
access to them.
any reviews or written complaints about the light that shines on the property?
No, what we do have are reviews that discuss how peaceful and relaxing and comfortable their stay was, how they enjoyed the environment. They were able to sit on the front porch and enjoy the quiet. We have those reviews.
So-
Mr. Vaughn, did you bring those?
Well, so let me ask this question, Ms. Barker. You mentioned, and I wrote down the quote, you said, if this gets approved, we will get bad reviews. I think you also went as far as to say this will kill our business. Do you have other case studies or examples of bed and breakfasts where a school got approved and it killed their business and they absolutely got bad reviews?
Well, frankly, the evidence shows that there are no other bed and breakfasts next to schools, because
Are you saying that with absolute?
why would you
that
put
there's
a
no
bed and breakfast next to a school where there's kids yelling and screaming and you're
I
trying
just
to
have
relax?
to ask for clarity for the record.
I'm
Are you
sorry.
saying that you examine every database across the country and there's no bed and breakfast next to a school anywhere?
We have a gentleman that did a report for us, and his report did not find any other bed and breakfasts next to a school.
Definitely have to object to that.
Yeah.
Well, he asked me.
Objection noted. No, I asked, but that's because it's got to have been submitted for the record.
State law says that
Do you have it?
evidence about appraisals, that requires expert testimony, and lay people cannot do that. That's a state law.
Wasn't the school there first? Because the school's
Yes,
been
the
there.
school was there
Yeah.
first.
Yeah.
I'm sorry, I didn't hear that.
No, the school's been there. The school was there before the bed and breakfast.
Yeah, so school and then bed and breakfast came. It wasn't like the other way around. It's just her point she's making.
Right, but the point I'm making, though, is where the playground is now, it is far enough away from the bed and breakfast to where the guests still can have an enjoyable, relaxing atmosphere. When the athletic field is going to be relocated right next to the bed and breakfast, which the bed and breakfast is here, and I don't have an overview, the athletic field will be right here. When that athletic field is relocated right beside the bed and breakfast, it will cause a problem.
So we've heard that part of your testimony, and this is
Right.
becoming a little repetitive.
I'm sorry, I'm
So-
just answering your question.
No, my question was, do you have evidence? And you said, no, you don't. So that was it. My next point is this. I think you mentioned that you've got nothing but great reviews so far.
We
Which-
have one or two bad ones where, what was it, the ones? Something about what was it?
I think the point that we keep asking is, did you get any reviews that said the school is negatively impacting your business?
Not right now.
Okay, understood.
That's sort of,
That's the last question I have about that.
So,
Looking into the future, which you can't.
right, as Mr. Vaughn
Completely
said, we can't
future.
predict the future.
No, I was asking about the past. You said you had 100 plus, and I know one of y'all said you never read them. So the person who did read them, did any of them mention bad reviews about the school?
No, because the reviews we have now, the guests are not disturbed by where the playground is. I brought up where the playground was because when I am up there working, I can't enjoy the area because the children are screaming and playing.
Yeah.
That's one class. So when you put the athletic field next to the house,
We get what you did. You speculated. We just wanted to make sure, to be clear, did you have evidence? Because you mentioned reviews, so we're just trying to, we keep coming back to
Right.
evidence.
I
If
don't
you
mean to be,
have-
I don't mean to be disrespectful, but I sat here and heard their testimony too. And some of these things that they testified to, they don't have evidence presented.
Well, so Ms. Barker, politely, very politely, it is up to this body to hear evidence from both sides. And I,
Right.
respectfully,
okay.
you can share your opinion about someone who's got certifications and everything and accredited and what they do. And if you say you don't think that is qualified enough, we get it. That's your
Respectfully
prerogative.
submitted, they don't live there. They don't run a business there.
Understood.
So he's presuming that he knows what's accurate.
Understood.
We run a business there. We would be more experts and professionals as to how we are affected by this proposal versus the young man sitting there. He doesn't live there. He doesn't run a business there.
Understood. I've got no more questions. And anyone else on council have questions? Okay.
Mr. Mayor, as the applicant, I do have a couple of questions.
Would you like to cross-examine?
Yes, sir.
Come on forward, please.
Great. Mr. or Mrs. Barker, do you know when you bought the property?
May 30th, 1996.
All right. Was there a school there at that time?
No.
Okay. When did you build the home on the property?
The home that I built on the property was built in December of 2006, was titled in January of 2007.
Was there a school on the property at that point?
In its infant stage, yes.
Okay.
And I also will add to that, I had multiple discussions with the previous schoolmaster.
Is that a yes or no question?
May I answer that with an explanation?
I would prefer you not. All right. When you converted the home to a bed and breakfast, when did that happen?
August of 2011,
Was there a school on the property at that time?
yes, in its infinite stage.
All right. We're looking here at a GIS image that has the wooded area in the back. When you bought the property, did you understand that that would remain wooded forever?
In the words of Tim.
Yes or no?
Yes, it was, yes, I did understand it would remain wooded forever.
And what made you think that?
So in testimony from Mr. Tim Montgomery, former headmaster of the Piedmont School, because it's on the watershed at that time, they were allowed to build the amount of impervious coverage based on the percentage of the land that they bought, that the land would remain wooded.
Do you have any guarantee of that?
Other than the verbal comment from Mr. Montgomery, no, I do not. I took the man at face value.
When you built the home, did you have any guarantee that that property would remain wooded?
Other than face value, no.
Okay. When you converted the home to a bed and breakfast, did you have any guarantee that property would remain wooded?
My previous answer stands.
Okay, great. Now, could that property be developed, subdivided and developed as residential property?
That would be subject to approval of the city zoning of High Point. So no, it cannot.
Is the property zoned R3, yes or no?
The property is zoned R3, and there are limits on lot size and access to the road.
If that property were developed as residential, would there be dirt and noise? Yes or no?
Of course.
All right, that's the only question I had for you. All right?
Can he not explain?
No.
No, he's doing
I'm
this.
asking for a yes or no question right now. All right. If that property were developed as residential and there were homes with children in the backyard, would you potentially hear noise?
If I
Yes or
chose
no?
to live
Yes
there,
or no
yes.
question,
If
Mr.
I chose to live there, yes.
Thank you. All right. Ms. Barker, you noted you make that you don't like assumptions. Is that correct?
I don't like the word assumption. There
Are
are
you,
other ways to
yes or no
explain it.
questions, please?
I don't like the
Noted.
word assumption.
Understood. Are you making an assumption that this school, as developed, will ruin your business?
No, I'm not making an assumption,
What empirical evidence do you have of that?
because we have guests who specifically state the reason that they come there is for the peaceful, enjoyable environment, the nature, and the fact that they are able to relax and enjoy.
Do you have any expert testimony with respect to the impact of this development on your business? Yes or no question?
Can I explain then?
Yes or no question?
I don't think that's very fair.
I'm going to take it you are answering no, you do not.
No, I didn't say that. Don't put words
Well,
in my
then-
mouth, please.
Yes or no question, please.
I have evidence from guests.
Understood. All right. Mr. Barker, did you attend the Citizens Information Meeting on July 16th, 2024?
Yes, I did.
Or June 18th, sorry, 2024?
Of this past summer, yes.
Yes. All right. Did you and I speak at that meeting?
Probably.
All right. Did you recognize that I gave a presentation at that meeting?
Yes, I did.
Okay. Were you aware that I gave out my email and phone number as part of that presentation?
Yes.
Okay. Have you followed up with me at any point between June 18th, 2024 and today?
I have done that.
Yes or no question,
No,
Mr.
I
Barker?
use the attorney.
Thank you. That's the only questions I have.
You got a question?
Mr. Quick, while you're up there, if I may, it's Councilman Moore and the Barkers as well. We've heard concerns about, from both sides, on what's going on, mainly on the Barker side about the effect on their business. I also heard very clearly that they, and I've stated before, that they felt like that there hadn't been communication between the two. We've established that upon a vote tonight, if approved, this takes us to point X, okay? Do you and your applicant, y'all help me out, it's getting late. Can we be assured that going forward, for the peaceful harmony of these two, if approved, that there will be better communication between each side of you beyond even what's in writing, that you can work for the better long-term harmony in the community? Can we do that?
I don't think I can answer that question as the attorney for the Piedmont School.
Okay, can
I
a
would-
representative for them?
Hold on, Councilman Moore, one sec. Madam Attorney's got a comment.
Probably finish with the Barkers as a party before getting into, we can bring it
Okay.
back up for a rebuttal and any additional questions.
All right, I'll redact my comment.
Okay.
Does anyone have any other questions for the Barkers?
If no one else has any other questions for the Barkers, we'll allow,
Does staff have any? No, okay.
okay.
Mayor Jefferson, may I bring up one more point to her 5 technical circumstances or requirements?
Sure.
Does the technical review and the implementing or the analysis of the technical review, is that part of those 5 requirements, that the technical view be satisfied?
The 5 requirements come from state law. So those are the standards that the council has to make their decision about the special use permit.
That's what I'm asking.
Okay. So the technical review committee is made up of staff from the transportation, engineering, planning and development department, where they review technical plans and things moving forward. So the technical review committee is not, they do not review in light of the special use permit standards. That is what council is deciding here tonight.
Is technical review not bound by those standards?
The 5 standards are what the decision for the use is. The technical review committee deals with the technical aspects of the site development. So Mayor, if you'd like staff to explain that further, they can enter testimony.
Well, let me, so just getting clarity, talking with Madam Manager here. TRC, Technical Review Committee, reviews technical plans, as everyone alluded here, technical plans come after a special use permit gets approved.
I
So,
was
so, so TRC would not come out at it, at
So
this point to
TRC
do
is
any
not
review of that.
held bound by the 5
Well, they'll,
criteria.
so when it comes time for technical plans, they'll be bound by all the state standards you want. But what you're asking for is TRC to come to your property before we approve the special use permit. And TRC hasn't even convened about this property yet. That's later from this. TRC looks at technical plans. This right here is a special use permit.
So, sir, perhaps your attorney can explain that to you, but it's different, it's different. So
All right.
this is a decision related to the use of the land, and state law requires the 5 standards that council must make their decision on. So that is, it's not that it's they're bound by it or not bounded, it is a different process.
Understood.
They will look at it for the technical review of the site development afterwards, but that would certainly be something that your attorney can help you with.
So for the record, if council approves for the use of the land, that decision is subject to all of the conditions being met and could be reversed if they are not met through further discussions and/or debate or evidence.
I don't think it's that it would be reversed. It's that nothing would move forward if they didn't meet all the conditions. So we would approve it tonight, but hammers don't start swinging tomorrow. They have to still meet every single thing that's supposed to be met. TRC at some point will do all the deep dive analysis on technical plans, and before anything can move forward, they've got to have the good buffer. They've got to make sure the lights are right. They've got to do all this stuff with the parking and everything that was noted in the conditions.
So to clarify, if those technical conditions are not met and/or changed and/or debated and are not met, essentially, in theory, could your decision become null and void?
Madam Attorney, would you like to clarify that?
Yeah, I'm not sure exactly what you're asking. So the decision tonight would be related to the special use of the land as has been presented. During staff's testimony, they presented that it runs with the land. If something were to come up during the technical review process that the applicant could not move forward, then they would essentially not move forward. But nothing done here tonight would be reversed. The special use and the conditions run with the land.
However, it would not move forward.
If
The development would not move forward.
No, I said if something, well, first of all, you're asking a lot of speculation questions. So these are all things that if something came up during technical review that prevented the matter from moving forward, then they would work together, see if they can come up with a solution. And if not, then this may not move forward. But that has nothing to do, that's outside of the scope of the hearing here tonight. That is something that comes afterwards through the technical review committee process.
Madam Attorney and Mr. Barker, I just want to make sure that I'm understanding to gain clarity on your question. You're asking if there are 5 boxes that need to be checked and the applicant can't check but 4. Does that mean that that they don't move forward? We won't have to come back and reverse a decision. That means that the applicant, if they can't check all 5 boxes, that they can't move forward with that. Is that what you're asking?
You're saying, to clarify what you just said, if we can't check off all 5 boxes, then the project cannot move forward. It won't necessarily be reversed, it just won't go forward.
If they don't check 5 boxes, they're not getting approved tonight.
Right.
Yeah, we're asking for, we're asking for approval for the special use permit
Right.
to be applied to this land.
Yeah.
What happens from this point forward on the more binding site plan has to meet more bars,
Stringent.
of which I think fall into what your concerns are.
It appears to be, yes.
And I think at that point, that's why I interjected, and I'm going to go back to it now unless you stop
Not a problem.
is trying to get the two of you to see that from this point forward, hopefully that communication will be there. They could be successful if approved, and you can be successful where you are and still together, okay? But that's not, we're not that far down the road here on this.
So at this point, we've heard it all. I just want to make sure, are there any other parties here to give testimony? That's our testimony. Okay, awesome.
Thank you.
Is there anyone else that intends to offer testimony regarding this case that would be a non-party? Okay. We'll now move to the section regarding rebuttal witness. I feel like we've kind of done that already, though, Madam Attorney. The rebuttal witness, I feel like we've already done that. Haven't we been hearing that already?
Ask if they have anything else to call
Okay.
all the parties.
Parties withstanding have the option to offer rebuttal witness testimony if they so choose. As a reminder, please focus on new or clarifying evidence and avoid repetition of evidence we already heard. Does the applicant, staff, or the Barkers wish to call any rebuttal witnesses?
We have something very quickly.
Okay.
Come up here real quick.
Council recognizes staff.
Yes. We're going to be extremely quick because there is a question about communication, and I do want it on the record about how communicative the staff has been. So, Mr. Shannon, can you tell me, when you received the letter from Mr. Vaughn as it relates to this special use permit, did you respond?
Yes.
Did you send an email on August the 9th to him explaining to him that he could go onto Acela and follow the process for how to keep up with this special use permit application and weigh in on it?
Yes.
And then additionally, did you comply with section 2.3.6 of the development ordinance that requires published, mailed, and posted notice?
Yes.
And so was that mailed notice sent to everyone within 300 feet of the site, including the Barkers?
Yes.
And was it run in the High Point Enterprise, the published notice on October the 5th and the 10th?
Yes.
And did you post a sign on the property communicating that there was a special use permit on October the 4th?
Yes.
Okay, no further questions.
Thank you. Are there any further? No further rebuttal from the applicant? Any further rebuttal from Barkers? Awesome. Thank you all. We'll move on to closing statements. Parties withstanding have the option to offer a closing statement or rebuttal argument if you so choose. First, we'll start. Does the staff or applicant or any other party, such as the Barkers, withstanding wish to make a closing argument?
Yes, the applicant.
Yes, the city.
Okay. Okay.
Well, I think, the applicant will go last as they have the burden of proof here tonight.
Okay.
So the staff may go and the Barkers, you can decide if there's an order that you'd like, but the applicant should go last.
Let's go staff, let's go Barkers, and then applicant.
Can you pull up the, is this it right here? Okay.
While they're pulling that up, please note that the evidentiary hearing remains. No, sorry, you go ahead.
And this is, okay. All right, Mr. Mayor, council members, thank you for your patience. I know everybody's looking to get out of here. We did provide this in the agenda packet, so I'm going to go very quickly through it, and if there are questions, you can. But I do want to point out that the whole point of this process is to take all the testimony that you heard tonight and to apply it to those 5 standards. That's what your sole responsibility is. And so to make that process a little bit easier for you, what we've done working with staff is come up with a summary, which is also in your staff report, a little bit more lengthy as to how those standards are met. Staff is of the opinion, and it's only been reaffirmed by this hearing, that the standards are met. So the first standard is that the special use will not materially endanger the public health or safety. The applicant, and I'm just going to briefly explain why the staff is of the opinion that this standard is met. The conditions that were offered, including limiting enrollment to 155 students for phases 1 through 3 and 200 students at build-out, and the TIA process that we've went over, these are all conditions that have been added in that are binding on the applicant, as well as the vehicle stacking plan that is in Exhibit C. This shows that the vehicle stacking requirements are 664 feet for phases 1 through 3 and 809 linear feet at phase 4. These are all conditions that help show that there will not be any danger to the health or safety to the property. So for those reasons, this standard is met. The next standard is that it complies with all the required conditions and specifications and standards of the development ordinance, including Chapter 4, which is the uses. Staff, as you can tell, thoroughly reviewed everything and has been negotiating for quite some time with the applicant to ensure that the conditions proposed would ensure that all the standards are being met of the development ordinance. And, you know, the other thing to point out is that in addition to the conditions, the staff ensured that the underlying standards of the development ordinance were also met. So, and that's, of course, important with a special use like this. The third standard is that it will not substantially injure the value of budding land. And as I mentioned, this under state law is only evidence that can be brought forth by expert testimony. So the only expert testimony that you have before you is an appraisal report from a North Carolina state certified appraiser from July of 24 that states that based off of comparable sales, that there will be no negative impact to property values. And as you all have stated, this is not a new use. It's been existing since 1999, and there's no evidence of decreased values based off the fact that a school was around. So for those reasons, the value standard, the staff is of the opinion that the expanded school will not substantially injure the value of abutting property. And then the harmony standard, which is that the special use will be in harmony with the area in which it's to be located, has been discussed at great length. But I do want to point out that this school is on the outer edge of adjacent residential neighborhoods already, and that the staff has pointed out that there has not been a need to travel through. Those stub streets are not being utilized and cannot be utilized unless additional construction is done. And then importantly, when you're looking at the harmony standard, we have to look at the surrounding area. And there are other institutional uses nearby, a youth camp, a church, the Elks Lodge, and the Oakview Country Club, which are all indicative of this being in harmony with the area. It is not only residences that are located nearby. The final point I'll make is that the applicant's own report, impact study report, showed that the surrounding uses are harmonious and compatible with the area. So the final standard is that the special uses is in general conformity with the city's adopted policy. As Mr. Shannon, you heard Mr. Shannon's testimony that the comp plan has suburban neighborhood place type for this area, and that encourages as a secondary use public and institutional uses such as schools. In addition to that, the R3 district, the development ordinance states that complementary uses such as schools and recreational facilities are allowed. So that's more evidence of this standard being met. So for those reasons, staff's opinion is that an expanded school in this area is in general conformity with the city's adopted policy guidance. So I just wanted to summarize the evidence and explain why the staff is of the opinion that those things would be met.
Will you come forward for the mic?
I'm not really sure it's appropriate to ask a question during closing.
Forgive me.
Yeah. You're more than welcome to get up here and ask or say whatever you want at your closing. Yeah.
Staff, thank you. Mr. Vaughn, if you'd like to go ahead and give the closing statement on behalf of your clients here, you can go ahead and offer it.
I'll make it close. What you just saw, unfortunately, was prepared before this hearing. So what we said here may not have mattered at all with the conclusions. I was going to ask him, when were these prepared? Before the hearing? Well,
Mr. Vaughn, if you'll address your closing statement.
I will,
Counsel.
but I feel like I should be able to ask him. Those were prepared before this hearing was held. What we have here is a unique case. By admission of the expert, having a bed and breakfast located right here next to this piece of property has not been done before. We worry about the conclusions that would be made by council and staff before the hearing was held. We make exception to that.
Thank you, Mr. Vaughn. If the applicant would like to come forward and give their closing statement now.
Yes, Mr. Mayor. I had slides, but I'm not going to worry about pulling those up. I'm just going to run through because Mr. Tosco did a very nice job of running through the 5 standards. And I'll add a little bit of additional context. First, the use will not materially endanger the public health and safety. Piedmont School has been operating on this site since 1999 with, in our opinion, no issue and maybe very little issue depending on where you sit. The expansion is going to require modern stormwater design, grading, and watershed planning, as we heard tonight, building code updates, and other things to bring this facility up to modern code. All of those things will help with the neighboring properties to the extent there are concerns about water runoff and those sorts of things. The phasing was designed to intentionally minimize the impact to neighboring properties and allow for an orderly and predictable progression of the project. There are several conditions related to safety that I'll note here. Location of the service areas, the dumpsters, the recycling areas, those sorts of things, at least 100 feet from adjacent residential properties, not to attract rats, mice, those sorts of things. There are conditions to limit light and noise pollution with respect to where no lighting here, and we are, that's it. No, we're intending to add no lights, and then we have a buffer here to protect against the remainder of the community. We're closing all access points other than from Old Mill Road. I will note that we initially had plans that included access off of Sandalwood, and in return of comments from the community after the Citizens Information Meeting, and before that, we decided we would go ahead and close that and not propose that here. We have a requirement for determination regarding the traffic impact analysis prior to beginning of Phase 4 to ensure the impact on Old Mill Road is mitigated to the extent that there's any concerns about traffic. Second requirement, that we comply with the development ordinance. Section 3.32 states that the R3 allows the complementary uses such as schools. We've already been through that. This is appropriate for this area. We propose conditions to restrict the access, again, along Old Mill Road. That meets the standard of 4.3.3C2, where you would have no access from adjoining residential local streets to this type of facility. We are meeting the requirements of the Type B, or we will meet the requirements of the Type B semi-opaque landscape yard. Whether we meet them today or not, we will be required to meet them. And so just noting again, we will comply with that ordinance. And then there's a catch-all that we must comply with all applicable local, state, and federal requirements. All necessary permits required for development must be obtained before any development can take place. This would include things like environmental permits, and building code requirements that we mentioned. So all of that is coming. This is a process. We're early in the process, but we have to cross all those things off before this project could proceed at any given phase. Third standard, the use will not substantially injure the value of the adjoining or abutting property. Again, the school has operated on the property since 1999, and we've seen, no impact based on its operation there. As we heard from our expert appraiser, we do not expect to see additional impact to the value of the adjoining properties. From the market impact study, the report that was entered in the record, this is from Mr. Crowder. Based on the data and the analysis, I conclude that the expansion of the Piedmont School, in accordance with the proposed conditions, will not substantially injure the value of adjoining or abutting properties. Page 46. The expansion of the Piedmont School has no associated stigma that is reflected in market-based data, page 45. Because other land uses are less sensitive to the external obsolescence than single-family residential properties, a finding of no impact to residential properties would apply to all other surrounding land uses. Again, page 45. In addition to those findings, we've proposed conditions to mitigate the impacts to the extent there could be any on the value of adjoining property owners. Ones we've already summarized, the location of the dumpster service area, restrictions on the outdoor lighting, restrictions on the use of permanent bleachers, and restrictions related to vehicular access from residential neighborhoods. So all of those things are there to help mitigate any impact to the extent there could be any. Fourth standard, the use is in harmony with the area in which it's located. Once again, it's been there since 1999, and it's been a good steward and a good neighbor to the surrounding properties in all that time. They intend to do that going forward. Proposed conditions related to lighting and the bleachers, all of those things, again, help ensure this remains in harmony with the neighborhood. We are not asking for things that go above and beyond or substantially change how the site is used. And then again, from the market impact study, the things that we've already mentioned, all of these help ensure that we are in harmony with the neighborhood. So I'll quote from the market impact study. I conclude that the proposed Piedmont school expansion will be in harmony with the area. Again, from Mr. Crowder's report, page 46. With the current Piedmont school already in operation, the use of the land will not change, providing further proof that the expansion will be in harmony with the area. Further down on page 46. And then finally, the development of the area, including as the already existing Piedmont School, in addition to High Point Elks Lodge and other institutional uses, including a church, house of worship, uses that are similar to the proposed expansion. Expanding the Piedmont School would not change the dynamic of the area. And we can even see here Camp Maranatha and other similar uses like that in the area. Finally, the use is in general conformity with policy guidance. Our proposed conditions ensure that the development remains consistent with the neighborhood character. It's taken into account. As Mr. Tosco summarized, the High Point 2045 plan recommends this area remains suburban neighborhood, and secondary uses there explicitly call out schools and education. We also believe that the Piedmont School furthers community outcomes as expressed in your comprehensive plan to make High Point a place that families and business choose over other areas like Winston and Greensboro. You heard Ms. Mackel note that individuals come here from other counties. This is something that is unique and attracting folks to this area that we think is important. So that ends for us our presentation today.
Thank you. We'll now move to the section for deliberation and vote. Please note that the evidentiary hearing remains open so that the council members who are here on the dais may ask clarifying questions if needed. I'll ask now if there are any council members who have any more questions for any of the parties or witnesses before we move into deliberation.
I had one question about are there security cameras or monitoring on the property right now?
Can we hear from the applicant, please, for the record?
Yes, we have security cameras inside the building and also on the perimeter, the outside of the
Will
facility.
you expand that to include the field?
Oh, yeah, yes, yes.
And have you ever used that to follow up on any of these reports of people being on property when you're not there?
So I was unaware of the recent one mentioned this evening. I did not hear anything about that. We've used them before, not necessarily from complaints that came in, but from things that we noticed. We do have a limited view, and that's partially because of how the school sits back along the driveway and where the power lines run. Right now, there's nowhere that we can put a security camera that's further down the drive. So everything we can see is on that playground area, the blacktop, the front of the building, and then the immediate perimeter.
And did you want to respond to the reason why the gate is not locked at night?
Sure, the front gate is what I'm assuming. And so to my knowledge, in the school's history, that gate has never been utilized. It's never been locked. I think that is information we can take back as a part of this process. I do want to point out that even with that gate locked, there is not a perimeter fence. So there's no, that is not a definitive way to keep outside folks off of our property. And oftentimes, what has happened when we've had security footage is that, I think we mentioned teenagers earlier, kids that come from the neighborhood sides or like through the forest area.
And do you think that the school is responsible? I mean, putting a soccer field is a pretty big asset to a neighborhood. Do you feel responsible for how that's used when you're not there, or the activities that might take place on the premises?
Sure. I mean, I think within reason and within our capabilities, I think we'll certainly go above and beyond to make sure that security cameras are out there, that we have sufficient, access where need be, and that we respond to any complaints that are brought to our attention. Yes, we will do so.
Thank you.
Thank you.
And any other questions from council?
Yes, I have one. Councilman Moore, does your school currently, the athletic piece of your organized sports, do they participate in weekend activities?
They do not.
Any other questions from council?
Thank you.
Hearing no additional questions, the council will begin its deliberation. As a reminder, council is tasked with making a decision based on the evidence presented during this hearing. This decision cannot be based on the personal preference of council members. Council members are reminded to reference applicable standards and specific evidence in your deliberation. Council can now begin its deliberation, and we certainly encourage active discussion and ensure that we're looking at the findings that were presented here regarding the standards. Any deliberation from council? I'll make a comment. The closing statement made by Mr. Vaughn talked about opinions being made here. Staff, as one of the parties, certainly made an opinion before they got here, but it's council whose job it is to listen to everything during this hearing and then make an opinion. And so we're taking everything into consideration. I hope you trust that during the time that your clients were up, we gave them plenty of time to answer as many questions as we could possibly ask, and even tried to search for as much evidence as possible to maybe substantiate something. But ultimately, I don't think any of us came up in here with our mind made up. We came to listen and be open-minded. So,
Mayor, if I could say, based on the criteria that our attorney has given us, I think there's only one way for us to vote. I think the evidence, the applicants have provided us with evidence that we need, and so I make a motion to approve.
motion's been made. I'm going to ask that you use what's on the paper to make that motion.
Okay. Okay, where is it? I would like to make a motion to approve the special use permit requested in application SUP-24-01 and adopt the proposed written decision in the staff report.
There's been a motion. Is there a second?
Second.
Second's been made by Councilmember Johnson. Any discussion on the motion to approve?
Yes, Mr. Mayor. Mr. Barker, while I'm sympathetic to your request, going through and looking at from an evidentiary standpoint, there was no history of historic negative impact to your business. There's no evidence of lack of downward detriment to your property values. And so in some of those major issues there just wasn't enough sufficient evidence for us to be able to rule for you. So I don't know if there was a time factor for you to prepare for that, or maybe to gather more information from your neighbors, but just from a fair hearing standpoint, looking at the evidence lodged by both sides, I just don't see the detriment that you feel. And I can be sympathetic to that, but I can't make a decision on my sympathy. So that's my final point.
Any final discussion from council?
I'll just make one quick comment. haven't been here for a while and been through a couple of these, but they're very, very rare to come up like this. We have a good problem in High Point. It's a good place to be right now, and it's growing. With those challenges will come a number of things similar to this, and we are certainly not, as a council, we're not lacking in seeing some of this type of emotion. Take HPU, for example. It happens quite regular. And it's never easy. As a small business owner, Mr. and Ms. Barker, I certainly respect and understand your concerns. That's why I'm imploring that both sides of you, now that you recognize the extent of the concern, that if this passes, that we work together because we're all sharing the same community, and we need to see if we can make both of these things work. Thank you.
Any other discussion from council? To ensure that the record has it correct, having looked at the 5 standards here, haven't heard the point about the access point in terms of how that impacts traffic, haven't heard that the TIA has not been triggered, haven't heard that the dumpster is considerably placed so that way it won't be disruptive, haven't heard about the lights and them not impacting nighttime, things of that nature. Haven't heard about the retractable bleachers, haven't heard about the appropriate buffer, haven't heard about the watershed being impacted well, and that they're going to do whatever mitigation needs to be done, or otherwise things don't get approved. Haven't heard about the market impact, haven't heard about similar uses in the area, haven't heard that the 2045 plan has a secondary use for schools, haven't heard about it being gated with cameras for safety, and haven't heard the lack of evidence of injury to property taxes. I would say that this council has done its duty of hearing as much as we can possibly hear tonight and find that it does rule in favor of the applicant in this case, and that all 5 are met. So with that, all those in favor, please signify by saying aye.
Aye.
Any against? The ayes have it. And with that, by a vote of 9-0, the special use permit request for application SUP-24-01 is hereby approved. Staff will finalize the written decision approved by the council today, including the evidence and considerations from today's hearing, and I will sign it. This written decision will be provided to the applicant and any other party with a right to the decision as required by law. Aggrieved parties will have the right to appeal the decision as provided in the development ordinance in North Carolina state law. Without objection, I'll close the hearing for application SUP-20-01. Thank you all. All right, back to our regular meeting. That was actually the very last item. Are there any comments or announcements from council before we dismiss?
We have the parade on Sunday.
Holiday parade is on Sunday, Main Street. I believe it starts at 3 o'clock.
Correct.
Yeah, it starts at 3 o'clock on Sunday, so feel free to join us.
And Saturday at 3 o'clock is the tree lighting at the plaza.
Saturday, if y'all will allow us to adjourn before you do all the talking. I'm sorry, Councilwoman Peters, what did you
I
say?
was just also saying that on Saturday at 3 o'clock is the tree lighting.
Saturday at 3 o'clock, there's a tree lighting in our downtown. Sunday at 3 o'clock, there's a holiday parade. Any other comments or announcements from council? Okay, is there a motion to adjourn?
So moved.
Second.
Motion's been made by Councilwoman McKeever and seconded by Councilmember Peters. Any discussion on the motion to adjourn? Hearing none, all those in favor, please signify by saying aye. Aye. Any against? The ayes have it, we are adjourned.